Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Oh, from sake.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican po, service love.
Is that correct?
Literally not true.
I didn't ask you to interrupt me.
Oh, for crumb's sake.
There we go. Good morning. Happy Friday. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you all with us this fine Friday morning. The weekend is nearly upon us. Got to give a huge shout out to Gabby for Justice. Congratulations, you're first in chat. First in chat comes with its punishment as well as its prestige. But and there was another P word that it comes with. Punctuality, that's what it was. Your punctuality is being met with punishment. Everything I purelated worldwide is your responsibility going forward today. Yeah, Judge Dad, we might watch that this morning. You want to watch Judge Dad really quickly? It was so funny. I think we got time to do that. Well, let's hurry and sing happy birthday, watch Judge Dad, and then we'll kick off court with the Judy Church trial. It's good. If you haven't seen it, it's worth watching again. Grandpa yet? Not yet, but they're at the hospital. So you guys literally could watch as I become a grandpa. I mean, I don't know exactly when it'll happen. I'm sure I'll get a text message or something. Hopefully within like the hour. You know, I'd hope that we're one of the first ones they call. but yeah. So Josh has the birthdays. Wonderful. Thank you, Josh. We'll let Josh get the birthdays together for us. And there, boom, there it is. Just like that. Thank you, Josh. Happy birthday to Ashlyn, Matthew, Melissa W., Sean, Becca, Laybell, and Marilyn Skull. We're going to sing happy birthday and then kick off Judge Dad, and then we're going to jump to court because we have to, because it's starting without, well, it's not starting yet. It's still just, it's just sitting there. But it will start soon, and we don't want to miss it. So everyone, wherever you are, if you're able and it's legal, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with a neighbor, and warm up with me if you will. La 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 la. Turn the lights off. That's funny. Okay. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Ashley, Matthew, Melissa W., Sean, Becca, Lee Bell, and Marilyn Skull. Happy birthday to you. Ashlyn, Matthew, Melissa W., Sean, Becca, Laybell, and Marilyn Skull. Where's it, Laybell? I think it's Laybell. Happy birthday. I realize there are many wonderful days, but today is your special day, and there are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn that joy back to you, make your day just a little more special. Or begin by helping yourself to bring free breakfast at Denny's, IHOP, Village, and Waffle House. Free pancakes at Denny's, IHOP, Village, and Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. Whew. There you go. J. McCarthy World says, I'm claiming this birthday song too since I forgot to come in on mine. Happy birthday, belated. How do you do it? McCarthy? I want to do two Mcs. J. McCarthy World. Is it just McCarthy? Why are there two C's? You're throwing me off a little bit. My last name has the same. It's the big M, little C. But I only use one C. McCarthy. There you go. McCarthy. That's it. All right. Happy birthday. I'm sorry it's belated. But welcome. Good to have you here as well. Dancers are doing their thing. Love the move. The kicks are flowing. Everyone has stretched and warmed up, which is great because we don't have workers' comp here. You injure yourself, it's on your own dime. I'm sorry. Just don't put that on me. Looking good, Sherry. Looking good. Denisha has the pancakes hot and ready. Just Stephanie's already serving dessert. The party has begun. Drum solo finished. All right, happy birthday. Let's jump to Judge Dad's court because it was so funny to watch this happen. Let's see, where are we at? I think.
Judge, if I may, really quick, I have an iPhone here that
Yeah.
I can't, I haven't been able to identify.
Oh, on the iPhone there. Sir or ma'am, can you start your video and tell us your name, please?
Yeah.
Oh, I've only done one of these
It might
before.
be-
My name is Kimberly Carroll. I'm sorry.
There
I was
she is.
sitting in some room or something, and then I didn't know. I was just sitting there staring at myself. I'm sorry.
Oh, boy. All right. You got to have your name on there, okay?
All right, how do I do that?
Well, you got to start your video right now.
All right, let's see.
Let's start with that. I just entered a
ma'am.
default judgment.
Is there as me?
You cannot be driving, ma'am. What are you doing? Come on.
I'm not driving. I'm a passenger in a car.
You're still not, I'm not hearing cases with people driving or as passengers in cars.
Okay, I will pull over right
Short of
now.
us coming out to everybody's house and doing these on boats and stuff in the summer, I don't know.
I'm sorry, I have an emergency. I'm going out of town for a family member, but I will have my driver pull over. Hang on 1 second. I'm sorry. I
Driver.
didn't know that I wasn't allowed to be in a car, but hang on 1 second.
Am I crazy or does it not look like you're driving that car?
I'm not driving the car. I'm a passenger in the car, sir.
What side of the car are you on?
I'm on the left-hand side.
How would you be on the left-hand side if you're a passenger in the front seat? Am I missing something?
Right-hand side. I'm sorry. I've been sitting in a room. I didn't know.
Yeah, the seatbelt's coming off of the driver's side. Right? Now you're lying to me, right?
No, I'm not, sir.
Let me see the driver. Let me see the driver.
Hang on 1 second. I
Now.
have to ask their permission.
Now.
Oh my God.
She gets out of the driver's seat.
Oh, you're not in the you weren't in the driver's side. You think I'm that stupid? I'm going to go ahead and enter a default judgment. Our paperwork says that that they can't drive. Does it not, Jennifer?
I'm sorry, Your Honor. I took a breath in and started choking.
I was laughing too hard.
Does
Your
our
Honor.
paperwork not tell people that they can't be in a car?
She's now in the passenger
I don't
side.
know, Your Honor. I'd have to look at it
The
again. I haven't
paperwork
looked
that
at it
I'm
in a while.
looking at, it does not say that I cannot be in a car.
I'm entering a default judgment. You lied to me. Judgment 1921-85. Send me your counsel and put in there defendant was not available at the time and then was driving a car and telling the court she was not. I'm entering a default judgment. Have a great day. Thank you.
Thank you, Your Honor.
I signed in at 1:30, sir.
Well, you got an attitude with you. I'll tell you that. You got an attitude. I'm not putting up with it. Nonsense. Good luck to you. Yeah. No, let's do them now. Unless you want me to do them tomorrow. You want me to do them?
She's lucky. She's lucky that was just a civil matter and not a criminal one, because that could have been really bad. That could have been really bad. But I'm sorry. I think the judge was right. I think she was driving. I think she was absolutely driving. But anyway, we are still early for court. Yay! Which is awesome because we've been late a couple days in a row. This is like I'm turning over a new leaf here. I'm a new person. This is the beginning of a new era. And we do also need to get a couple of things on there. There we go. Got the counter. We're looking good. The straight face line to the judge. Can you imagine if she? Oh my goodness. I thought that was hilarious. She was like, am I seeing something? Am I seeing things? Because that seatbelt's coming out of the driver's side. What side of the car are you on? Left. It's like, let's see. Yeah, that would put you in the driver's seat. I mean, right. Right. Show the driver. I have to ask their permission. Can we get the new leaf? No, Schmoopy. We just take what we get and we don't throw a fit, right, Schmoopy? She would have to take her eyes off the road. Not a grandpa yet. Not a grandpa yet. I am not a grandpa yet. That I know of. They went in last night, and any time now. Literally any time now. All right. New pin message above. Let me find the pin message here. We are on the what maybe the final day. Hang on, let me scroll up here. Red pin. We'll start the day with I took a breath in and started choking. That's what you want me to pin? Was there another one? Let me keep scrolling. That's it. That's what you wanted to pin. Is that right? Oh, the not a grandpa yet. Oh, not a grandpa yet. Okay, I'm sorry, Red Pen. I'm like, I'm not sure what you needed. Let's see. I'm trying to find the right not a grandpa yet. Pin message. There we go. I become a grandpa today. That's the plan. That's on the schedule. And so thoughts are with my son and daughter-in-law as they begin a new phase of life, which is going to be filled with revenge for me. All the things that he put us through as our first child, I hope he gets to experience for himself. How far are you for them? 2,500 miles, just down the road. About 6-day drive. I don't know. It's a long way. It's a long way away. So we're excited. All right. Stop yelling, yells Chuck Norris. Thank you. Yeah, I'm super excited today. She was driving. 100%, Barb. 100% she was driving. Live stream of the birth. Members only. A purple coconut. Yeah, we've got. We're trying to get that feed going. No, I don't think any hospital would allow that. And probably YouTube either. I'm pretty sure YouTube would strike that one as well. Yeah, we're hoping for a very, very safe, everyone's healthy delivery. For baby, grand RA, and mom. Happy Grandpa Day. Thank you, Kelly H. I'm so excited. I really am. I can't wait to begin to spoil the grandchild rotten. It's going to be a girl, by the way. We told you that, right? It's not going to be. It is. It's a girl, and not going to share the name because that's they want their privacy there. But super excited. Where's the new gavel you made? Oh, thank you for. Ninnis and I, well, mostly Ninnis, have been working on a Golden Gavel Award, which we 3D printed. I 3D printed here at my house. This is the design Ninnis made for us, and it printed beautifully. It's a 3D printed gavel and a 3D printed base, which has room for a little plaque. I'm not sure if I'm going to do I printed the 65% scale, so it's nearly half the size we originally designed it at. But I do like this size because I like to be able to print both of them at the same time. It takes about 4 hours and 13 minutes total. It said 5 hours, but it printed pretty fast. 4 hours and 13 minutes to print one of these, and it just looks nice. I really like it. So I'm going to say approved. So we might be making these and sending them out maybe towards the end of the year when we do the Best of Awards. We also might make something for our moderators. I give them a little thank you. So, all right. This was fantastic yesterday. We did do a live stream members only because I have to do a couple more of those. I've actually got a meeting at noon today. I'm supposed to be done with all my members onlys, but I think I officially have till the end of the month. How much do you think it cost you to make that? Probably about $4 in resin in PLA filament, because it's only about 200 grams, and a spool of 2,000 or 2 kilograms is about $20. So $2 or $3. then, of course, you got a little bit of time and energy, but all right. And then it says it took a few hours to design. Yeah, there were many different iterations and changes, but let's see. No audio yet from court, but let's see if we can bring video. Yep, we've got hair, so we're getting there. We're getting there. It looks great. And then it's absolutely, I approve. It is wonderful in every way. I didn't look and see how many watchers we had on the stream.
Back on the record with case on trial.
Here we go.
And good morning to all.
Good morning, Judge.
Good morning, Your Honor. Good morning, Mr. Scully. Mr. Norkunis, what is the decision of Ms. Church whether or not to testify?
She has chosen not to testify, Your Honor.
Okay. Ms. Church, I'm going to have a brief conversation with you about that decision. If you would stand up just while we chat with each other. No need. Ms. Church, Mr. Norkunis has told me it's your decision not to testify at this trial. You've heard me state over and over again throughout the course of this trial to this jury that a decision of a defendant whether or not to testify is theirs to make. They have an absolute right not to. And if you do not testify, I am prepared to tell this jury in my final instructions that they may not consider that in any way in assessing whether the Commonwealth has proved the charge made against you. And I'll go so far as to tell the jury that they may not even discuss the fact that you've chosen not to testify in their deliberations. What I want you to understand, however, is that you have an absolute right to testify if you wish to do so. Do you understand that?
Yes.
It's important that you have consulted with your attorneys, Mr. Norkunis and Mr. Scully, about this decision, and I have no doubt that you have. I've provided opportunity for you to do that. And it's important that you give due consideration to their advice and counsel because they're very able and experienced attorneys. But in the end, it's your decision whether or not to testify. Do you understand that?
I do.
So regardless of whatever advice you may be receiving from your attorneys, if you wish to testify, you have the right to do so. Do you understand that?
Yes.
Is it your decision, Ms. Church, not to testify?
Yes, it is.
Thank you. You may be seated.
All right. We will not
just
be
a
hearing
couple of
from the
other
defendant.
housekeeping matters, or really matters that relate to the instructions, and we're still waiting for 2 jurors, by the way. First, with respect to my practice, which you may or may not have noticed in reading the instructions, of letting the jury pick their own foreperson, does anyone have an objection to that practice? Mr. Camilio?
No.
That's normal,
All right,
Judge.
very good. I think I sent the added instruction, the Commonwealth requested instruction on prior inconsistent statements. I was operating and addressing that particular request under the federal rules of evidence and not ours, uncorrected by anyone else, I might add, that these statements come in substantively. They do not. So actually the limiting instruction is appropriate in any event. As I said in my email to Ms. Draper that I think she probably included in her email to you, I just worked right off. There's a very good district court model instruction, which is what I used. Any issues with that instruction, Mr. Camilio?
No, just thank you for saving no issues, Your Honor.
All right. 2 other things about the instructions that I've tweaked just a little bit that I want to bring to your attention, and I haven't yet printed out copies because I'm going to go back and send them to our judicial secretary, and each counsel will have their own copy. But first, in terms of selecting a replacement deliberating juror, should we come to that, what I've always said in my instructions is that we would just select the first chosen alternate to go in first. If we lost the deliberating juror, then the second alternate. I've tweaked that a little bit, really to comport with Ms. Draper's fairly standard practice, and I think it's probably a fairly standard practice elsewhere, which is that if we were to lose a deliberating juror, we just take the 4 selected alternates, put their numbers in a drum, and randomly select a replacement, and do that anytime we needed to select a replacement. Any issues with that, Mr. Camilio? Mr. Scully?
No issues, Your Honor.
All right. Finally, I did a little tweak to the section that discussed the verdict form because I realized I referenced 3 options: not guilty, guilty first-degree murder, guilty of second-degree murder, which did not reflect the fact that there's 2 theories of murder. So there's really the options are really 4. So I just tweaked it to reflect that the verdict form has not guilty, guilty first-degree murder, deliberate premeditation, guilty of first-degree murder by extreme atrocity or cruelty, or guilty of second-degree murder. So those are the only changes I've made. Any issue with that, Mr. Camilio? Mr. Scully?
No, I don't think so, Judge.
That's all I had. 2 defense witnesses this morning?
Correct. 2 defense witnesses, both present.
Both present. Excellent.
Excellent.
We're all set then. All right.
We got the
So
jurors.
you can line them up and bring
Just
them in.
I just have one thing before we bring in the jurors.
Sure.
I did get an email from Mr. Scully last night about the medical records that he plans to read to the jury this morning. And obviously, I don't have a problem with reading some medical records to the jury, but this, by my count, is 17 pages of medical records, which I think might be...
That is too much.
I think it comes down to about 25 words.
In total?
I think it's something like that. So the pages are, there's a date of a page. So I gave them the page rate for the medical records. So like page 43 to 46, which is part of Exhibit 8. I'll read the date and then turn to page 46 and read the 5 words on that page that I highlighted. And then I'll go to the next one. So I think it came out to like 25 or 30 words.
So you're talking about just a minute or 2 in front of the jury?
I think a minute or 2. My plan was to just, because I don't want to drop the paper.
That's acceptable. I think Mr. Camilio's concern was you were going to be up there reading 17 pages. That's fine. That's fine. Absolutely fine.
Jennifer Juniper, OG.
One last thing is it's my expectation that we will hear the testimony of the 2 defense witnesses. The defense will rest. We'll excuse the jury. I'll hear the defense motion, and then we'll give counsel a break before we proceed to part 1 of instructions, closings, and then the final instructions.
Thank you, Ron.
All right. So we're set whenever the jury comes in. Do you want to?
I'm going to.
Yes, copies for them. Okay.
This had the incorrect docket number. So
Oh, okay. Yes, we are. Thanks, Matt.
The judge is single-handedly going to get us to 1,000 coughs today. Put this last one on there. 845 now. This is the super spreader trial. This is where it all started. When the world ends and we all are infected by disease, you'll know that it began in this courtroom, this very courtroom. Kate, I'm so excited. We are thrilled. Can't wait. We're just watching the phone for the news. And you'll probably be able to tell when we get that news. Sounds a touch better. I don't know. I think he's just warming up. Debbie, who knew you were going to be the closest guest? That was amazing. I think it's going to be right close to 1,000.
All right,
Leanne, thank you very much for gifting 5 memberships. Also, previous to this, Ladybug's mom gifted 5 memberships as well. Thank you very much.
Be seated.
Good morning, jurors. Since we saw each other yesterday afternoon, has any member of the jury discussed the substance of this case with anyone, including among yourselves? No. Since we last saw each other, has any member of the jury seen, read, heard, or overheard anything from any outside source about any aspect of this?
The judge has no arms.
We're continuing with the presentation of the defense case. The defense counsel may call their next witness.
Thank you, Your Honor. Defense calls Dr. Edmund Crouch.
Bree, thank you very much.
May we pause for just a moment? I want everybody to stay in place. I'm going to absent myself for about 30 seconds. I forgot to do one thing before I brought you in. We have finalized the jury instructions. I need to send them to our judicial secretary to start copying them, and I want that to occur while the witness's testimony is going on. So people stay in place. I will leave the bench. No stand up, sit down. I'll just come and go in a moment. I'll be right back.
So we get the rare jury is present but judge is not moment in court. We don't get to see this one very often. Nobody talk to the jury. This is.
I'm gonna stand over here.
Yeah, stand right here. Judge told you to stand right where you were. Don't move. Everyone's being obedient, except for one lawyer. I hear a chainsaw in my neighborhood. Somebody's cutting down a tree. Got one cough there in the background. He forgot his hands in chambers. Normally, you'd think that's what you have a judicial assistance for, you know? Prop the door open for security, yes. And convenience. There's one more cough there.
What did you do while I was gone?
Sir, would you raise your right hand, please? Do you solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. You may be seated.
Short version.
Thank you.
Morning, sir.
Good morning.
Dr. Crouch, there's a microphone in front of you that not only will amplify your voice so the jury and others hear it clearly, but it also is recorded. So if you can stay as close to that microphone as comfortable and possible.
Thank you.
That
Is
will
this
be good.
okay?
Yes. I think so. So in a loud, clear voice, could you please introduce yourself for the record, stating your first name and spelling your last name?
My name is Edmund Crouch, Crouch.
And I referred to you already as Dr. Crouch. What is the basis of that title?
I have a PhD.
Okay. So Dr. Crouch, with respect to that, could you describe for the jury your educational background?
I started in a high school in England, what would be called a high school here, public school. It was called a public school in England, which was actually semi-private. Moved from there to Churchill College, Cambridge, where I studied natural sciences and obtained a BA in natural sciences, which automatically converted to an MA after 3 years of good behavior, and subsequently did a PhD in theoretical physics.
Okay, and where did you obtain a PhD in theoretical
physics? This was all at Churchill College, Cambridge, England.
And how long have you been a PhD? Or what year did you obtain it, if you recall?
About 1972.
Okay. And that was in England, obviously, right?
That was England, yes.
And you still have your English accent?
I'm told that, yes.
You live in America?
Yes.
And in the greater Boston area?
Yes.
For how many years?
It's now, I think, 40...
Why is he rolling his R's?
49 years, something like that. I came over in 1977.
And could you briefly describe for the jury any professional associations that you belong to? And if there's a long, long list, you don't have to name them all, but to give them a sense of those.
Well, I'm a member of the American Association of the AAAS. I forget the full nomenclature. The American Mathematical Society, the Mathematical Association of America, the Society for Risk Analysis,
Bean Counters R Us.
Maybe a couple of others. Oh, the American Chemical Society.
And over time, have you published papers and articles in the field that you work in?
Various papers in various fields as I move through various fields of work.
Now,
The English don't roll their
employment-wise, what do you do now?
Now I'm part of a two-person small company, both of us semi-retired. We consider ourselves consultants. We work for clients on pretty well whatever they want to do with chemistry, risk assessment, toxicology. My colleague is a chemist and toxicologist. I consider myself a risk assessor, but that covers a wide range of fields, but primarily risk assessment of chemicals.
Okay.
Risk assessment.
And prior to that, from 1992 to 1994 or thereabouts, were you a lecturer at Harvard University?
For a short time period, yes.
And after, during that period and until about 2012, did you work as a senior scientist at Cambridge Environmental Incorporated in Cambridge, Massachusetts?
Yes.
And after that, were you a principal at C.D. Smith in Cambridge?
Yes, that was my title, I believe, there.
Okay. And have you also associated with Harvard University in the Department of Physics for many years?
Yes, that's what I came over originally in 1977 to work as a postdoc in the Jefferson lab.
Okay. And so did there come a time when you were approached by the defense team, in this case, to look at the amount of ethylene glycol that was present in certain locations?
We're getting some audio clipping.
Yes,
Sorry about that.
Okay. And could you describe basically, you know the name Fowler, right?
Yes.
Did you undertake something to look at how much ethylene glycol was in his system at the time that he died?
Not at the time he died, at the time he first presented at Anajac Hospital.
And so part of what you did was look at how much ethylene glycol was in his system when he first presented at Anajac, right?
That is correct, yes.
Did you come to a conclusion about that?
I did, yes.
What was that?
My conclusion was that he held, at the time of presentation, he had about 28.5 grams of ethylene glycol in his system.
Okay. And in order to get to that conclusion, how did you get there, basically, if you could explain to the jury?
Yes. I started with the measurement of ethylene glycol in his blood performed at NMS labs on behalf of the state police labs.
Let me see if I can fix this. Give me just 1 second.
I contracted it out to NMS. That was a measure of 52 per deciliter, which is the same as 520 milligrams per liter. Now, ethylene glycol, when it gets into the body, when it's ingested, is absorbed fairly rapidly and spreads throughout the body, carried around the body by the blood. And in the body, in the blood and throughout the body, it's dissolved in the water of the body. It doesn't dissolve pretty well at all in fat and protein and muscle and bone. It's just in the water component of those parts of your body. Now, we can estimate accurately the total amount of water in the body. This is a subject which has been extensively studied in the literature because it's useful in pharmacokinetic calculations. And it can be estimated accurately from one's height, weight, and age. And I estimated that using the best available methodology in the literature, and that came out to 46.5 kilograms, 45.6 liters of water, which is the same as 46.5 kilograms.
We've got some terrible
which is
audio
about
clipping.
51% of
Very
Mr.
choppy.
Fowler's body weight. I'm a presentation to Anna Jacks. So, with that information and the concentration in blood, well, that's the concentration in blood. The concentration in the water is a little bit higher because blood is only about 85% by volume water. So the concentration in the water, in the blood, and hence in the total water in the body is higher by a factor of 1 over 0.85. It's 85%.
Not.
Sorry, not 80%.
Not.
1 over 0.85 times the concentration in blood, which gives you 612 milligrams per liter. So now it's 612 milligrams per liter and 46.5 liters. Multiply the two together and you get 24,800, I think it was, milligrams of ethylene glycol in the whole of the body water, and that means in the total body, which is 28.5 grams total.
Okay. And so, so you were able to come to that conclusion, and you were largely on the medical records from Anna Jake's hospital and the laboratory records that tested his blood at NMS laboratory, right?
Yes, Anna Jakes gives me the body weight when he got there, have the date of birth from various sources to get his age, and the weight, and his height was measured at autopsy as 5'10". So I've got his height, weight, and age.
By reviewing the autopsy report and records.
That's correct,
okay.
Yes.
Now, so you've got that calculation for the amount of ethylene glycol in his blood at presentment at Anna Jake's.
Well, in his whole body.
In his whole body.
Yes.
And did you then also seek to determine how much ethylene glycol was in what's been referred to as the sample from the Powerade that NMS tested in this case?
Yes. Again, the State Police Lab contracted out to NMS and they measured the residue from the Powerade bottle so that if the bottle had been full with liquid corresponding to that residue, so it was the same stuff as that residue, the residue contained 2,400 milligrams per deciliter, which is 24,000 milligrams per liter, which is 24 grams per liter. And the bottle was a 20-ounce bottle, 20 fluid-ounce bottle, which is exactly 0.6 of a liter. That's a USDA requirement for labeling, that you have 1 fluid ounce is exactly 30 milliliters. So multiplying those two together, the volume of 0.6 liters and the 24 grams per liter gives us 14.4, I think it was, grams of ethylene glycol in a full Powerade bottle containing a liquid similar to the residue.
Okay. So what was left in the Powerade bottle was sort of a residue amount, a small amount, right?
Yes.
But it had a percentage of it that was ethylene glycol, right?
Yes.
And you remember what that percentage by weight was?
Well, it was about 2.4%. That's 24 grams per liter.
About 2.4%.
Yeah.
And then what you extrapolated is if the bottle had been full to its 20 ounces, then it would have contained, based on the 2.4%, 14.4 grams of ethylene glycol, right?
If it was the same as the residue, yes.
If it was the same.
If the contents of the bottle were the same as the residue, yes.
So in order to get that amount of ethylene glycol that was in Leroy Fowler's blood system, would drinking one full bottle of the Powerade have been sufficient?
No.
Okay.
It would require about twice that, two bottles full.
So would it be fair to say that it would require at least 2 bottles?
Yes.
Okay. All right. Thank you very much. No further questions, Your Honor.
Mr. Camellia.
Thank you, Judge. Good morning, sir.
Good morning.
Before I get to your math, we'll call it, I just wanted to ask you a few questions.
We'll call it math.
About ethylene glycol itself, okay?
Yeah.
All right. So ethylene glycol, it's a chemical, found in various consumer products, correct?
As far as I know, yes.
Okay. Well, you actually wrote that report.
Yeah.
So you do know that.
Yes.
Yeah. And one of the main places that it's found for consumer products is in antifreeze, yes?
I don't know the relative amounts of ethylene glycol in various different consumer products, but antifreeze is certainly a major component.
Okay. Ethylene glycol is a sweet-tasting liquid, yes?
Yes.
Okay. And because it is sweet-tasting, it can be dangerous, correct?
Apparently, yes.
And because it is sweet-tasting and oftentimes colorful, it can be accidentally consumed by some people, right?
Yes, it is indeed accidentally consumed by quite a few people, unfortunately.
And in order to try to prevent people from drinking it when they don't know that it's in whatever they're drinking, this bittering agents are added to it, correct?
Yes.
Okay. And unfortunately, bittering agents have been shown to not prevent the ingestion of ethylene glycol, correct?
That's correct, yes.
Right. Once we started adding bittering agents to antifreeze, the number of ethylene glycol poisonings in the United States remained basically the same, correct?
That's true, yes.
Okay.
Wonder why that is.
Now, in order to do your calculations, which I will confess, law school did not prepare me for you had to make some assumptions, correct?
Yes.
All right. You had to make an assumption about the total water in Mr. Fowler's body.
I had to calculate that.
Okay. Well, but you don't know. You calculated based on averages, correct? Based on averages for an average person, 5'10", weighing Mr. Fowler's weight and Mr. Fowler's age.
That's correct,
Okay.
yes.
So everybody's different, and so
Yes.
those things vary from person to person.
Yes.
Okay. And if an individual is dehydrated, the amount of water in his body will be lower.
Yes.
You also had to make an assumption about how long it takes for ethylene glycol to reach equilibrium in the total body water, correct?
That's correct, yes.
So depending on the number that you choose for that assumption, that would change the amount of ethylene glycol that was present in the body water, correct?
Yes.
Okay. So when a drink, and I'll just use my bottled water here as a substitute, when somebody drinks a liquid containing ethylene glycol, or really containing any liquid, first place it goes is into the stomach, correct?
Correct.
From the stomach, it then goes into the bloodstream.
Well, usually from the small intestine or the intestines rather than the stomach, primarily.
He takes a swig.
And then it hits the bloodstream.
Yes.
And then it starts to make its way through the water in the body.
Yes.
Okay. Now, at some point, a substance like ethylene glycol that hits the bloodstream is going to hit what's called Cmax, correct?
Well, define what you mean by Cmax.
Cmax is the highest concentration of that particular substance in the blood. Yes?
If you define it that way, that's the way it is, yes.
Not familiar with that term?
I've seen it in multiple situations, multiple contexts.
All right.
I mean,
and so Cmax at some point is going to be higher than the concentration of whatever that particular substance is in the body of the the total body water, correct?
no. I mean, if it's the concentration in the blood, it's the concentration in the blood.
Well, it's the concentration in the blood, but the concentration in the blood is not the same as the concentration in the water.
For some period
Of time.
The concentration in the blood will be higher than in the total body water on average, yes.
Exactly. So if the blood was measured at a time when the concentration in the blood was higher than the concentration in the water, that would affect your calculations.
Yes.
And your calculations would essentially not be correct.
They would not be correct if that was true, yes.
So the takeaway from your testimony, as I understand it, is that it's possible that the blood was measured before all of the ethylene glycol hit the water in the body.
In this case, no.
No, not. Okay. Why not?
Well, Mr. Fowler was observed, I believe, at least 7:30 and possibly earlier, already under the influence of some substance.
Mm-hmm. Fair.
So
and it can take up to 4 hours in a healthy person for that ethylene glycol to reach equilibrium in the total body, total water body. Correct?
No, it would be a bit shorter than that.
So
2 hours.
Shown between 1 and 4 hours is how long it takes for ethylene glycol to reach equilibrium in the water of the body.
Now, I would say at most 2 hours.
And as you noted in your report, if someone has particular health problems, that can cause it to be even slower.
No, that slower thing is the metabolism, which is a different thing entirely.
So you agreed with me that if the ethylene glycol in the blood was higher than in the body total body water, your calculations would be incorrect. Correct?
If that was true, but in this case it was not.
Okay. Well, thank you for that. So your conclusions can either be broken down into two things. I know you're not going to agree with me that your calculations are wrong, but that's one possibility. The other possibility that you're raising is that Mr. Fowler was actually being poisoned in multiple doses.
Not necessarily.
Not necessarily. Well, he had 52 milligrams per deciliter of ethylene glycol in his blood. Yes?
Yes.
Okay. And you say there wasn't enough in the Powerade bottle to have gotten his blood to 52 milligrams per deciliter, correct?
Yes.
So the rest of the ethylene glycol that was in his blood had to come from somewhere.
It came from somewhere else than from one drink of Powerade, of that bottle, assuming that the residue is the same.
Assuming that the residue is the same. And that's another assumption you had to make.
That's correct, yes.
Thank you, Judge. I don't have anything further.
Mr. Scully.
So basically, based on your calculations, assuming the residue was the same, you would have had to have drank at least 2 bottles of that Powerade.
Well, there had to be some other source, or not some other source entirely, yes.
Okay. No further questions.
Mr. Committee, follow up on
No,
that?
thank you, Judge.
Thank you very much. Dr. Crouch, you may step down.
Dr. Crouch may step down. I don't know. I spent a lot of time in England, and I never ran into people that rolled their R's. I think it's something that's done for TV only. I think he might be faking his accents a little bit.
The next defense witness.
For prestige.
Thank you, Your Honor. Defense calls Dr. Stephen Lakin.
Last witness, Dr. Stephen Lakin. I think we'll have no rebuttal by the state. They were only going to call a rebuttal if that doctor came in. The one lady, I forget what her name was.
Sir, do you solemnly swear the testimony you are about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
He said he got a PhD instead of a PhD. He needs to say H if he's going to roll his R's to keep the illusion up.
Morning.
Good morning.
As you know, the microphone there projects your voice for the jury to hear it, and it also triggers the recording, which is taking place, so transcripts can be made later, if necessary. So just please use that microphone to the best of your ability.
I will.
Okay, thank you. And in a loud, clear voice, could you introduce yourself to the jury, say your name and spell your last name for the record?
Good morning. My name is Stephen Laken, Steven, Laken, Laken, and I have a PhD in cell and molecular medicine from Johns Hopkins.
Okay, and so that's why I refer to you as Dr. Laken, correct?
Yes.
Dr. Laken, in addition to that PhD, could you summarize basically for the jury your educational background?
Yes, I earned my Bachelor's of Science degree from the University of Minnesota in genetics and cell biology. I worked as a technician for a year. I was accepted into graduate school at Johns Hopkins Medical School. I worked on my PhD for 5 years. I earned a great degree in cell and molecular medicine. My concentration was in genetics and cell biology. I then joined a company called Exact Sciences, which helped commercialize an FDA-cleared colorectal cancer screening test called Cologuard. And then since that time, I've been working on a number of startup companies, help consult with companies that are working on new diagnostics devices, and also do the DNA forensics work.
Okay, and so just so I'm clear, did you study at the University of Minnesota and obtain a bachelor's in genetics and cell biology?
Yes.
And did you study thereafter at Johns Hopkins School of Medicine and obtain a PhD in cellular and molecular medicine?
Yes.
Okay. And did you complete your education, graduate from Johns Hopkins in 1999?
Yes.
And been working in the private sector since then?
Yes.
And currently, what is your job?
Currently, I have a company. The company's called Cephos, spelled CEPHOS. Since between 2007 and 2008, I started working with attorneys, consulting on DNA forensic cases. Most of my work is all of my work is working on the defense side, and I've worked on around 1,300 cases, as well as a number of wrongful conviction cases.
Okay.
All defense.
And is it fair to say that in that area of work that you do now, frequently defense lawyers such as us give you DNA data and reports and conclusions that were generated in cases by the Massachusetts State Police Crime Lab?
It can be the Massachusetts State Police Crime Lab. It can also be private labs or other states.
Okay, and sometimes the crime lab contracts out with other laboratories to do certain types of DNA work?
Yes, that's correct.
And is it fair to say that you get all the data and do a top-to-bottom review of it to see if you spot issues?
Basically, what I do is ask for what's called the DNA case file, which is generally the lab's notes and written contemporaneous records along with the testing that gets done. I ask for those along with what's called the raw electronic data, basically the data that goes into producing a DNA profile. There may be criminalistics reports. In the cases of criminalistics reports, those are people that are basically analyzing the evidence at the crime lab, maybe taking pictures or doing certain serological testing or testing for biologic fluids. I may review some police notes and police records. And then basically I come to my own opinion and then communicate those to the attorney.
Okay, and did you undertake to do that in this case with respect to the DNA evidence that was provided to you by us relative to this case?
Yes.
And do you recall looking at DNA evidence relative to item 2-1.2.1, which was described as the handle and an exterior cap of a bottle of de-icer?
Yes.
And is it fair to say that several profiles, at least 3 profiles, were generated as a result of DNA testing done on that item?
Yes.
Okay. And you reviewed those profiles and that data to see if you identified any errors, correct?
Correct.
And did not?
Correct.
Okay. And there was also DNA data and materials presented to you in connection with item 2-2.2.1, which was described as the sample of exterior Powerade bottle.
Yes.
And similarly, this sample, what was presented to you is there was a number of profiles, at least 3 profiles generated in connection with that, right?
That's correct.
And you did a review top to bottom to see if there were any issues with those profiles.
Yes.
Fair to say, didn't identify any.
Correct.
Not challenging those.
Correct.
And then there was the a third item that I would draw your attention to, which is 2-2.3.1, which was described as the sample of mouth of interior cap of the Powerade bottle, right?
This has changed a bit over the years.
Again,
this is from his website.
That had at least 2 DNA profiles, right?
Yes.
And you looked at the data behind that to see if there were any issues that you disagreed with in terms of those generating those profiles, right?
Yes.
And you did not.
I did not find any issues.
Now, so the profiles are not necessarily an issue that you're here to testify about, right?
That is correct.
You looked at them, but that's not what you're here to talk about today.
Yes.
What we want to ask you here today is about, well, how does DNA get a person to an item?
There are 2 different types of DNA transfers that are generally referred to in the field. One is called primary transfer. So primary transfer is when I'm touching or handling an object. For example, if I pick up my notebook here, I handle this notebook, then I'm leaving the DNA potentially from my hands onto that notebook. That would be a primary transfer. My DNA is on that notebook. Now, when I walked into the courtroom, I opened up the door. It's possible that in the process of opening up the door, I collected somebody else's DNA who opened up the door before me, and that DNA may be on my hands. That would be a case of secondary transfer. Their DNA went through, for example, the doorknob, and then I picked up that doorknob, or I picked up the DNA from the doorknob or the door handle, and then I've transferred that, or it's on my hands. So DNA can get transferred multiple times. It can be left on objects for quite a long period of time before it degrades away and disappears.
Okay. So primarily, direct contact is one way where you touch something, right?
Correct.
And secondary transfer is another common way, right?
Is another way that I can pick up somebody else's DNA inadvertently and transfer their DNA or handle their DNA.
In primary direct contact cases, DNA exists in what form in terms of cells, saliva, other ways that it would be transferred?
We're constantly shedding our DNA. Most of the way that we shed our DNA is through a process of skin cells or the cells that are on my face. We can also transfer DNA through the process of talking. In fact, or talking or sneezing, as the case may be.
Or coughing.
We also may transfer a lot of our DNA externally that way. So, for example, in the laboratory, to take precautions to prevent me from leaving DNA on objects that are being tested, wear a face mask to basically prevent any DNA if I cough or I sneeze, or even in the process of talking, I may be leaving and spreading DNA from my mouth. I wear basically gloves, and the gloves are to prevent my DNA from my hands being transferred to any object. And the sleeves in the laboratory are a little bit different than a common lab coat that's worn. The lab coat that's worn, the sleeves have cuffs that are relatively large, and those cuffs are basically meant to go across my wrist. And then when I wear gloves, I can put those gloves and overlap those gloves on my wrist so that there's actually no gap between the gloves and my lab coat such that DNA may be dropping down on top of things. I also wear a hairnet in the hairnet or a beard net are those to basically prevent DNA from my hair or the skin on my hair from shedding off and landing in tubes.
Okay. So is it fair to say that a DNA analyst or scientist, when they detect DNA present on an item, that's not the same as detecting when and where or how that DNA got on the item?
That's correct.
All right. And when and where and how is really outside the scope of the DNA expert's abilities, right?
That is correct.
You're looking at profiles. It's there, or it isn't there, or there's a percentage chance that it's there. A statistical chance.
So yes, that's absolutely true. The statistical chance is when we see a profile, what's the chance of finding a profile that's similar to that in the population, not the chance of finding a profile left on that item.
So we have, as an exhibit in this case, a Powerade bottle, which is identified as Exhibit 30 here. So if I'm following what you said correctly, one way that DNA can get onto this bottle is through sort of a direct handle touch primary transfer. Is that right?
Yes.
And a second way could be if the person who's doing that direct touch of the bottle also has DNA of someone else that they have picked up somewhere along the way, right?
Yes.
Either directly from having contact with that person, right?
Yes.
Or sharing a bed with them.
Yes.
Or touching a door handle.
Yes.
Or just living in the same home.
Yes.
Okay. And is a third way that possibly this surface here that I've been using could have my DNA on it, right?
Yes.
Might or it might not, right?
That's correct.
Probably
The
has
surface,
the judges.
Has been here a long time. It could have other DNA on it, right?
Yes.
Okay. And is it possible that if an item is placed on this surface, that there could even be a transfer that way?
It's possible, yes.
Okay. All right. Thank you very much, Doctor. I have no further questions.
You're welcome.
Ms. Strasnick?
If I may just have a moment to grab a couple exhibits.
Yes, you may.
This guy also does like paternity cases, like you are not the father stuff. Sort of man of many talents. Knows how DNA spreads, and he's quite aware that all these coughs are spreading DNA and other things around the courtroom.
Want me to find it for you?
Trying to patch together the best audio I can for you, sometimes even combining two different sources so that we can make one complete picture. Got me working overtime here in the background. There's another cough. 879. It's called Baby Daddy DNA.
One exhibit I can't seem to find.
Missing evidence? What? Say it ain't so.
Good morning, Dr. Lakin.
Good morning.
You reviewed the work that was generated by the Massachusetts State Police Crime Lab in this case, right?
Yes.
And you'd agree with me that they're an accredited lab?
Yes.
Their analysts pass proficiency and competency tests, right?
Yes.
And it's your opinion that the Massachusetts State Police Crime Lab is one of the best that you have observed?
Yes.
And you've had many opportunities to actually go to the lab and make observations of them conducting various types of DNA testing, right?
Yes.
All the things that you just described to the jury that's important to protect the integrity of testing, such as the gloves, the mask, the hairnets,
Yes.
the coats, they do all those things, right?
Yes.
And you've observed that, right?
Yes.
You'd agree with me that you're not a DNA analyst, right?
I'm not a DNA analyst.
You're not a forensic scientist, right?
I'm not a forensic scientist.
In fact, as you stated, you're a defense DNA expert, right?
I wouldn't say that I'm a defense DNA expert, but I am a DNA expert, yes.
How many times have you testified for the Commonwealth?
I have not been asked by the Commonwealth to testify, but I'd be happy to. And
How
so
many times have you testified for the defense?
probably around 60 or 70 times.
And how many cases have you done work for the defense as a DNA consultant?
I have about 1,300 cases.
And it's fair to say that being a DNA expert for the defense has become quite lucrative to you, hasn't it?
This
It
portion
pays
of the trail
bills, yes.
sponsored by
In fact, in 2026, the
shampoo,
fiscal year,
Head
you
and
made
Shoulders.
over $200,000 just for Massachusetts cases where you've been retained as a defense expert, correct?
My company has billed that, yes.
And between you personally, because you used to charge personally and then you changed it to CFOs, is that how you say it?
Cephos.
CFOs for the billing. And during the course of your time as a DNA expert with Massachusetts, you made approximately $2 million doing DNA cases for the defense, right?
Yes, I've been doing this since 2008, correct.
I didn't hear the witness's answer.
Yes, I've been doing this since about 2008.
2008.
2008, yeah.
So we talked a little bit about secondary transfer and direct or primary transfer, right?
Yes.
And that's what I want to talk to you about. Secondary transfer, you said DNA gets on an item indirectly through another person or object rather than direct contact, right?
Yes.
So some type of casual contact from the environment in which someone or something is, right?
It could be casual, yes.
Are you familiar with how blood is taken at a hospital or at a medical provider where it's put in vials, right?
Yes, I've taken blood samples as well for DNA.
Okay, so perfect. You're familiar with that. You put the blood into a plastic or glass vial, right?
That's correct, yes.
And if I were to shake your hand and I touch the vial, you're saying it's possible that your DNA might be on the outside of that vial, right?
Can you rephrase? Can you just ask that question again? I'm sorry.
Yeah, sure. So if there's blood in a vial,
Yes.
I've shaken your hand, and then
Yes.
I touch that vial,
Yes.
you're saying it's possible that your DNA would end up on the exterior of that vial.
You and I shake hands and you touch the vial. It's possible that my DNA from your hands could end up on that vial, yes.
And you use the word possible, and I think you also use the word may, but you don't know.
When DNA ends up on an object, it's not possible to tell how that DNA or when that DNA ended up on an object. That's
So
correct.
It's possible, but not probable, right?
I wouldn't give a probability of it because there's no probability statement that can be made from that. So statistically,
You don't know.
it's not possible to come up with a statistical
And
statement.
you'd agree, no matter whether it was your DNA possibly on it or my DNA possibly on the outside of that tube, neither of our DNA is going to be inside that tube, right?
That is correct.
I want to talk to you about direct transfer. DNA can also be transferred directly, right?
Yes.
For example, if I hold the handle of a firearm and shoot someone, my DNA could be on the handle of the firearm, right?
Yes.
If I hold a bottle, my DNA could be on that bottle, right?
Yes.
Are you familiar with buccal swabs?
Buccal swabs, yes.
Where are they taken from?
The buccal swabs, the cells inside the mouth are called buccal cells. And so a buccal swab is basically the passing of a cotton tip or cotton swab over the outside of the cells in the mouth.
He's doubling down on
And
pronunciation.
it's taken from the mouth because it's the easiest and cleanest and most reliable source of DNA, right?
I wouldn't say the most reliable source, but I would say that it's an easy source to take samples from, yes.
Well, isn't the inner cheek and the mouth lined with epithelial or skin cells that are constantly shedding?
They are, however, in the process of doing things like kissing or sharing drinks, it's possible that one could end up with DNA from somebody else in their mouth. I would say when you say the most likely source or the cleanest source would probably be blood, because people can't really change their blood and it doesn't mix, and it's a very good source of cells. So I think blood is a better source, but it's not often taken because it requires a venipuncture. There's some safety issues in terms of personal protection.
But you'd agree that swabbing of the mouth provides DNA that has both skin and saliva, right?
I don't think that the mouth has skin cells in there. I hope it doesn't have skin cells.
It doesn't have epithelial cells that are shedding constantly?
Epithelial cells are different than skin cells. So epithelial cells are basically cells that are on the exterior of organs. So skin cells, for example, would be epithelial cells. Buccal cells would be epithelial cells. So yes, the mouth does have epithelial cells, just not skin cells.
I want to talk to you about Exhibit 30. Attorney Scully asked you some questions about this item, right? 20.
20.
Exhibit 20.
Yes.
You know what that is?
It's a Powerade bottle with a cap.
You'd agree with me that to drink from that bottle, you have to remove the cap, right?
Yes.
And the mouth of the bottle is inside of that cap, right?
Yes.
Could you remove the cap?
Yes.
You'd agree with me that the inside of the cap isn't exposed until you just remove that cap, right?
That is correct. Yes.
The area is covered when the cap is closed, right?
Yes, ma'am.
It's not exposed to the casual contact of the environment unless that cap is removed, right?
Yes.
Someone wouldn't touch that area unless they opened it, right?
Yes.
You'd agree with me that not only does the cap of a bottle prevent spilling, but it also protects the area of the bottle you drink from, right?
Yes.
You'd agree that it acts as a barrier between the outside world and the drinking surface.
Yes.
To drink from that bottle, a person would need to place their mouth on the opening, correct?
Yes.
Your lips would make direct contact with the rim,
Yes.
and that's how most people drink from a bottle, correct?
Yes.
So the mouth of the bottle is in the exact area someone's lips would touch when they're drinking it.
Yes.
So finding DNA there is consistent with someone drinking from that bottle, right?
It may be consistent with that. Yes.
You said that you agreed with the results of the Massachusetts State Police Crime Laboratory in terms of their DNA analysis and their statistics, correct?
Yes.
I'm going to show you what's been marked as Exhibit 61. So you agreed that the DNA of Leroy Fowler was 9.96 tillion in favor of his DNA being present on the exterior of the Powerade bottle, right?
The statistical statement you gave needs to be read in full. I'm happy to read the statistical statement. I don't disagree with the Commonwealth's report.
So you agree with the statistics, and this is a large amount of DNA that was present, correct?
It was not a large amount of DNA present.
It was a full profile, right?
It was a full profile, yes.
And you agreed that Barbara Randall was excluded from any part of that bottle, right?
I do.
I have no further questions.
Mr. Scully.
No further questions. Thank you very much.
Thank you very much, Dr. Lakin. You may step down.
Thank you. Thank you.
And with that,
You want me to?
You can just leave that right there. Thank you, sir. Does the defense rest?
Judge, defense would move.
Oh, I'm sorry. You go ahead, Mr. Scully.
Thank you, Your Honor. Defense would move in the next exhibit. I believe there's no objection. This is the deed to the property in Florida, and I'm looking for the address at 3965 East Lake Park Drive, Hernando, Florida, owned by Judy Church and
All right, then that may be admitted as our next exhibit. I take it there was no objection?
no objection.
Exhibit 67, so marked.
And with the court's permission, may I
Read some medical experts.
publish this to the jury
Oh,
briefly?
yes, you may.
So this is Exhibit 67 on the screen.
see, that's the deed. But we're going to focus on her hair instead. Okay. That was a double. Oh, man. Yeah, we're definitely getting another
And lastly,
100.
with the court's permission, we have several entries from medical records of Mr. Fowler we would like to read to the jury.
Yes, you may. Jurors, yesterday, just as I allowed Mr. Camilio on behalf of the Commonwealth to read a few excerpts of some notebook entries, all of which are part of the evidence in this case, have been admitted as exhibits and are available for you to review. I'm going to permit Mr. Scully to highlight a few passages in medical records that have been admitted as exhibits, are available in full for your review, but he's going to read a few passages, and I think in each instance he'll identify the medical record and the date. Go ahead,
Yes,
Mr.
I
Scully.
will. Thank you, Your Honor. These are all from Exhibit 8.
Also, non-dramatic reading by Mr. Scully.
Best I can, Judge. Thank you. So from Coastal Medical Associates, Leroy Fowler, November 13th, 2015.
Would you tell me that date one more time, Mr. Scully?
November 13th, 2015.
Thank you.
Anxiety, chronic problem, insomnia, chronic problem. From Coastal Medical on April 28th, 2017. Abdominal pain of unknown cause. From Coastal Medical on July 11, 2018. Past medical history, depression. From Coastal Medical, August 27th, 2019. Treatment number 6, bipolar 1 disorder. September 30th, 2020, Coastal Medical. Assessment, hypertension due to drugs. And lastly, from June 13th, 2022, Dr. Shane, Office of Dr. Shane Murray, history, chronic lower back pain, abdominal pain, impression, moderate constipation.
Yeah, I'm good.
Thank you, Your Honor.
Thank you. And with that, Mr. Scully, does the defense rest?
Yes. Defense rests.
Thank you. Jurors, we are going to take a recess. We'll allow the attorneys to collect their thoughts. And when we reconvene in about 20 minutes, we will proceed to some preliminary or pre-closing instructions by me, and the closing arguments, some additional instructions by me, and then deliberations will begin. So we're going to take that break right now, give counsel, as I say, a chance to collect their thoughts and get ready for the court.
All right.
We've got a poll up right now. Has the state proven the case against Judy Church? The first answer is always no. There's a presumption of innocence. Answer carefully. Don't click the wrong answer or it's on you. I'm not going to rerun the poll because you made a mistake. Susan Basterk, member for 26 months. OG. Thank you very much. Thank you. Man.
Court is back in session. Thank you, Susan.
Oh, that one got us.
Mr. Scully, you have a motion.
Yes, Judge, may I approach?
Yes, you may.
I think I printed this the other day, so it says 326, but.
This motion was ready the other day. 2 days ago. No, just 1 day ago.
But I am happy to make argument, but also waive argument at this time.
All right. Thank you, Mr. Scully. The motion for a directed verdict has been renewed at the close of all the evidence. I do not find that the Commonwealth's case, viewed in the light most favorable to the Commonwealth by the jury, has degraded through the presentation of the defense case to the point where it changes the determination that I previously made, which is that the evidence is sufficient, construed in the light most favorable to the Commonwealth, to satisfy beyond a reasonable doubt the elements of the charged offense of first-degree murder on both theories. And so I therefore deny the renewed motion, and we'll take that recess of 20 minutes or so, and then we'll reconvene for instructions and closings.
Thank you.
Thank you all.
Preston Jenks, member for 35 months.
Before we go, one thing.
On the jury.
At the beginning of the trial, there had been some discussion about expert testimony that ethylene glycol could be a substitute for cocaine or used for various things by a cocaine addict. None of that came in during the course of the trial. So I would just ask that the court instruct the defense that they cannot argue that in the closing.
Mr. Norkunis?
Judge, I think the medical records are full of, he has polysubstance abuse from both tobacco and cocaine, or within each of the 3 medical records. They're also in his own personal medical records, which are all now exhibits within this issue here. I don't think that I was going to rely significantly on that, but I think that my memory is testimony did come in from several of the civilian witnesses about his cocaine use in here, I believe. I think it was Mr. Hawkins, if I'm not mistaken, had talked about it.
There's certainly evidence. There's evidence about Mr. Fowler's cocaine use. Mr. Camillo is correct to my recollection, and I was listening for it. I didn't hear any competent medical or toxicological testimony by any witness that, for example, someone in the throes of cocaine withdrawal, if they have a substantial substance use disorder with respect to cocaine, might seek out ethylene glycol and intentionally ingest it. We had that discussion during the motions in limine, where I made plain that I would not permit that to be argued unless competent supporting testimony was presented so that the jury would have a basis for drawing such an inference. It has not been presented, so I won't permit that argument. That is that the jury might find that Mr. Fowler would have intentionally ingested a mixture, a drink of some kind with ethylene glycol because he was experiencing some sort of cocaine withdrawal. That's not permissible because there's no supporting evidence.
I don't intend to make that type of statement, Judge. My statement that's in my notes here would be he's at one of the most climactic moments of his life. The medical records show you that he suffers from depression, he's bipolar, he has polysubstance abuse, he has a pacemaker. The hospitals indicate that also his use of cocaine and cigarettes are a concern.
That's all evidence before the jury. I don't have an issue with you saying those things.
It's not my, and that's the position.
Mr. Camillo just wants to make sure that you're not taking that one step further, because if you did, he'd have to object. I'd have to strike it, which is, just as I've just said, which is to suggest to the jury someone like Mr. Fowler, who may have been abusing cocaine, you might find would have sought out ethylene glycol. There's no basis for the jury to draw such an inference because there's no supporting medical testimony of any kind that people who may be cocaine users do such things.
I'm not going to say what other people knew. I'm going to say what condition he was in. One of the most climactic moments in his life. He's at the hospital and he has EG. There's testimony from many witnesses that have said people on their own do consume ethylene glycol.
Oh, he's saying self-harm.
I think Mr. Camillo just asked Mr. Crouch about that.
That you may argue anything that's in evidence, and in the fair inferences from the evidence that doesn't require some expert testimony that hasn't been adduced or presented. So, I'm not going to micromanage the closings. This was one particular issue of concern to Mr. Camillo. You're not going there, and that's fine. Okay. Thank you all. So we'll be in recess, and then we'll reconvene.
Court, all rise.
One last cough. All right. As they go to recess for just a little bit, and we're going to sit and wait. We are counting the coughs. We have 921 coughs so far in this trial. About 900 of those were the judge, and they were bad. They were bad. I cannot. I did a members only yesterday while we were waiting because I had to get a couple done for YouTube. And I played a song called Grandma Hates Barbie Dolls, which I don't think I can play today. It just doesn't feel right. With Barbie dolls being the code word for Barbara. My in-laws lived right behind me, Sweet Elementary School, where she worked. Great neighborhood school, great neighborhood. Feels right. Okay, let me. We've got a lot of new people here who don't have any idea what song I'm talking about. Okay, let me do this. Sometimes, as we're watching court, we find it helpful to recount the events of the court in musical form to help us understand the happenings and what happened. Sometimes it helps us see the other side a little clearer. Sometimes it helps us try to get a perspective of the defendant. Sometimes it's just funny. And it's generally sort of irreverent, and there will be an element that just does not like it. We do this, though. We do this. We sort of this is in the same. This is similar to how police officers often have a dark sense of humor, right? They respond to a lot of calls where, that could be just emotionally devastating to the average person, and they respond and they crack a joke between each other. It's sort of in that nature, right? So this is not meant to offend anyone. But we'll play the song. This particular song was suggested by someone. You guys are offended. If you don't like these songs, then I'd suggest turn it down for just a little bit. But I'll play the one that someone who's not claiming ownership suggested specifically, even offered prompts as to what it should be like, how it should sound, and all that. So it's a pop song because of the Sun-Kissed Fanta situation. And we're going to play the song anyway. Oh, man.
Ooh, Grandma's in the kitchen, stirring up a treat. Sweet like candy with a little extra heat. 67 years, young retired teacher glow. Living with Leroy, but he got that side hoe. Barbers all plastic, perfect hair and smile. So Grandma nicknamed her Barbie and plotted for a while. Fruit punch, Powerade, birthday boy's delight. She gave it a swirl under the kitchen light. Said if you ever cheat, I'll fix you right. Now the whole town's whispering, was it just a joke tonight? She smiled real sweet, held the camera tight, recorded him twisting, asking what you take tonight. Voodoo dolls in the drawer, maybe just for fun. Pins in the chest while she's singing in the sun. Grandma hates Barbie dolls, yeah she really does. Jealous heart in a pink cardigan, what's the buzz? Little sip of something special in his favorite drink. Now the jury's sipping tea, trying to read the ink. Grandma hates Barbie dolls. La 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 la. Turns the heat up when the love gets cold. So cold. Antifreeze dreams in a Leroy told his fam she's doing something to me. But grandma kept cooking, sipping her tea. 13 little videos, evidence so neat. Defense says she's quirky, prosecution says delete. Powerade bottle glowing with that suspicious hue. DNA on the rim, ethylene glycol too. She said I'd never heard him, cross my heart and hope to. Oops, now the courtroom's giggling at the soap opera scoop. Birthday morning special, mixed with extra care. Called 911 later like she wasn't there. Silver hair shining, looking oh so innocent, while the town's playing detective, wondering where the evidence went. Grandma hates Barbie dolls, yeah she really does. Jealous hearts in a pink cardigan, what's the buzz? Little sip of something special in his favorite drink. Now the jury's sipping tea, trying to read the ink. Grandma hates Barbie dolls, la 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 la. Turns the heat up when the love gets cold. So cold. Antifreeze streams in a bright orange glow. Grandma hates Barbie dolls. Whoa. Is she guilty? Is she sweet? Or just a grandma tired of being second seat? Love triangle drama, pins and Powerade. Either way the story's getting served on a silver tray. Grandma hates Barbie dolls. Put her on the stand. Pink sweater, silver hair, playing innocent hands. Bottle don't lie and the videos don't bend, but maybe it was love gone a little off the deep end. Grandma hates Barbie dolls. Hey, hey. Grandma hates Barbie dolls. Tell it to the judge. Grandma hates Barbie dolls, but she swears it was all just a joke. Sweet like candy, but the recipe's wrong. Grandma's still singing her little song. Grandma hates Barbie dolls.
Oops. Yeah, there was the, we'll go ahead and put that up on the, now that it's been played, it's got its big debut, we will publish this one. Let's see how we do this. Publish, there we go. It's going to be on our list. I have to name it, sorry. All right. I will tell you, I did try to make a song previous to that, and it just came out way too dark. So we do make those songs with the aid of a few computers, and that's what turns up. That one. Thank you, Red Pen, for the inspiration on that one. I'm going to go ahead and close out. First of all, we're getting rid of the pin message because we're done with all the testimony. We're also going to take look at the results of the poll, which we have posted. Link for the songs. Yes, we can put that up. It's right there. There's all our court playlist. The one I made for this song trial we used the same voice as Daisy and the Walls, right? We used the same band, so to speak, and it was pretty dark. It was a little much. I ran a little test listen with a few people, and they agreed it was dark. So stop the AI garbage music. Yes, this is exactly what we're talking about. All right, the results on the poll as we end it here. I'm showing that the song should be called Next Tuesday. Yes, please put chat on screen. That would be helpful. There we go. Let's see. Where's the results? Okay, results of the poll are here. Has the state proven the case against Judy Church? Yes, 85%. No, 15%. That's with just over 500 votes. So a good population, good representative population. But 85% is not a That's one holdout, right? That's one and a half holdouts. So interesting. We'll see if the jury's able to reach a unanimous decision here. Oh, never mind. Camilla voted no by mistake. So, did Corey's trial have a song? I don't think we made one for Corey. I don't think we did. A couple of you voted no by accident. We do put no up there first, which throws you off. A lot of people just think the first result is yes, and then no second. Corey Reed or Corey Richens? Yes. That was my mistake all throughout the trial. I'm sitting here mentally just going over the evidence that we've heard in this trial, sorry, Blackbird here. I do not play other people's videos. Or you realize even with permission, it opens up a floodgate of requests. Is what happens. And I can't do that because I would have to. I mean, somebody could slip something in one frame of one video and then pause it at that time and make it look like I'm showing something that I had no idea was part of. I just cannot do it. It's not a copyright strike thing. That's one issue, but I just can't play other people's videos for that reason. It would open the floodgates. But if you right click on Blackbeardier's profile, you can go to their page and see the. I know you are. I know you're fine. But it's like letting a camel the nose into the tent. Soon the whole camel's going to be in the tent, and the rest of the camel is everybody else. And I get all sorts of flack if I'm not even with everybody, if I'm not fair all across the board, and you played theirs but you won't play mine type of thing. I can't. I just can't do it. I'm not a camel. Okay. Courthouse has been painted. I saw some head movement in there. Somebody might be coming back in. Why is there a camel? I was camping in the woods. Hang on, we've got a call coming in. Just one second.
Call from Selena.
Hey, Selena, how are you doing?
I'm good. I just thought I'd call in case you missed my voice, which I'm sure you haven't.
You haven't been our court watcher this time around. It's a little bit of a drive to get you out to Massachusetts, but I
am planning on going to Tyler Robinson if that happens and when.
Now they're on speedy trial, right?
Mm-hmm.
So that's going to be quick. Normally, the time between a death and the murder, the associated murder trial, usually is 3 years. Is what it normally is. Obviously, speedy trial cuts that way down. So it'll be interesting if that goes forward at that schedule.
So yeah, some of the hearings have been closed to cameras, so I don't know how the security is going to work with that one.
I think it'll be generally open. I think that's the ruling the judge has made so far. He's open to video cameras in the courtroom, but he's also aware that in some instances, some witnesses possibly might have to be not shown on camera, and so there'll be some trade-offs a bit.
Yeah. Yeah, Greeners, I wish it was 29. My birthday is Sunday, but it's not 29. It's 61.
It's 29 again for the 32nd time, right? So.
Right. Well, anyway, I just thought it'd be funny. I know some people are annoyed with me, but I really don't care. I thought I would call.
We loved it. We loved it. It was great. Thank you very much, Selena. Appreciate
it.
Also,
I need to mention real quick, too, I got permission to out him. Corey, he is he watches you, but he's not in chat. He is an anonymous watcher. But he was the guy sitting with me in the courtroom some days.
Awesome. Corey, the lurker.
And I talked to him. Yeah, so say hi to Corey, the lurker. I told him that I was going to out him today. So anyway,
awesome. Corey, make yourself known in chat. Hit the subscribe button.
Yeah,
Wait
we're going to
5
make
minutes
him
and say hi. So.
All right.
Thanks, Selena.
Good
Appreciate
luck
it.
on the baby.
All right. Thank you so much. We'll see you.
Okay.
Bye.
Bye.
Couple membership milestones. Frosty Jenks member for 35 months on the jury. Thank you very much. OG. Gigi Sharebear member for 30 months. OG. R.A. Happy soon to be Grandfather Day. Being a grand is wonderful. I'm looking forward to it. Today's the day. Irisy Dogs member for 37 months. Please play Grandma Hates Barbie Dolls. We did after some arm twisting. Also, Irisy Dogs. OG. Thank you very much. And I think that gets us all caught up. Oh, Shelly Small just gave another 5 memberships. Thank you. And said, I wonder if the judge is a smoker. I don't know. I don't know if he is. I think it's mostly just that he's sick. He's just, he's just not doing well. So hope everybody in the courtroom soon is going to be recovering. This is usually something that lasts a couple of weeks from what I hear. But let's see. Are you covering the Lindsay Clancy? I don't know yet. We'll have to check and see. Kells Bells, thanks for 5 gifted memberships. Appreciate it. I used to twist my sister's Barbie dolls. Barbie doll. I almost said that badly. Barbie doll arms. Did I miss closings? No, closings are coming up next. Actually, we get a little bit of jury instruction and then closings. Red, you were absolutely right. I misjudged you. I'll never do that again. Kells Bells, thanks for gifting 5 memberships. You guys are wonderful. He said last week he was sick. Coughs linger for weeks. Yeah. Little shake in the camera. Might have some action here. Let's just hold tight. See if we're coming back. Please no, Elsie. It's just too sad all around. I don't remember the facts of the case, the Lindsay Clancy. Oh, earthquake. Oh, we're right in the camera. We're leveling it out. Good work, folks. Good work. Last day of trial. We finally leveled the tripod. Are they at the hospital yet? Yes, they are. My son and my son and daughter-in-law and soon-to-be grandbaby. I guess grandbaby's already there because she's sort of with the daughter-in-law. But they'll all be we're waiting with pins and needles, waiting for a text message. Lindsay Clancy unalived her kids. Yeah, we struggle with the ones that involve kids are tough. We've done a few of them. They are just very difficult. Oh, now we're falling over. I'm sorry. We're leaning. We're like we've taken a hit. We're going down, folks. We're going down. Okay. Good level right there on that side. Yes, we generally don't do that. Jeffrey Spence retrial. That's the hung jury one, right? I forget. That's Mississippi? I think it's Mississippi. Okay, we're still all over the place. How do we find out what is the next case? Well, Michael, we typically don't announce it because we like to stay with one case until it's over. And if this case sits in jury deliberation for 3 days, I don't want to start another case and be in the middle of opening statements and then say, oh, wait, no, we've got a verdict, jumping back. Just because it makes it very difficult for anyone who's on a rewatch or watching through the playlist saying, I want to rewatch this trial, I want to rewatch that one, to find those pieces on YouTube. I haven't found a good way that doesn't involve me spending a whole lot of time chopping up videos and re-downloading, reposting, and we try to stick with the case until it's over. So once this is over, we'll take a look at what's available. We're not adverse to going back and watching on replay, as long as it's a case that we can catch up to before it's done. Because it's never fun to have everyone know the result of a case and us still be watching testimony. But we're not sharing the Kelsey verdict in here. Did not watch that one. We wanted to. That was one that we had put on the list of we want to be there, but it just didn't work out schedule wise for us. And fortunate for us, it would have hit us with a strike, a YouTube community strike. Some of our friends, fellow creators, got hit with that strike on closing day, and that would have shut us down for 24 hours. Just have to be. There's a lot of decisions that have to go into choosing a case, and even though it's a trial might be really good, it might not be a good trial for us. We're everywhere. And it's still crooked. After all that, we're still 2 degrees off, counterclockwise. Okay, now it's right. And that's better. You're good. Don't touch anything. It's perfect. Well, it's close to perfect. Let's see. Cheryl TV Live should be back up today. Today will be their 24-hour timeout. Should be over. Is there a reason you say no verdict if you aren't streaming it? Just because a lot of people in here are going to go back and watch it and binge watch it on the weekend. We try not to spoil things for people. That's all. Let's see. Griffin asks, would you vote guilty or not guilty? I want an honest opinion. Don't say guilty because Leroy was my father. No, Griffin, here's what I'll say. The evidence that convinced me of Judy's guilt, because that's where I am, was not circumstantial. I mean, we have a text message from her expressing her desire to poison someone, and that she has someone selected. This is like you're peering into the mind of the accused, and now we have a set of facts that match that, and we have 13 videos that seem to show her enjoying the process, watching it happen in front of her and unfold. Combine that with all the evidence, it seems like a no-brainer to me. I'm definitely on the guilty side. Let's see. It's not a good look for that. Judy, not good, just awful. It was bad. It was really bad. I realize she said some pretty nasty things about some people, right? That in and of itself is not evidence at all. The name she had for Barbara, that's not evidence. That doesn't sway me one direction or another. But the fact that we've got that poison in his drink, I think she did use antifreeze. I don't know if she might have got antifreeze out of state. I have no clue. Okay, there are some states where you can buy antifreeze without a bittering agent. I know in my state it doesn't require it. North Carolina does not require a bittering agent in antifreeze. I'm not sure if there are places that make it without the bittering agent, or if everyone does it just for safety reasons. But she may have got it. It may have been something that he just couldn't taste. But people just don't drink that for fun. It's not. I mean, there's zero evidence that he had any ideation of self-harm. There's there's nothing. He was planning and working towards later things in life just fine, and just out of the blue suddenly he's been poisoned. That's let's see. I think New Hampshire doesn't require it. They're about 10 minutes. I'm pretty sure that most of the big manufacturers put the bittering agent in regardless of whether it's required. It's not expensive, right? The bittering agent is very, very inexpensive. It's the amount that has to be added to make it bitter is minuscule. I mean, like tiny. That's how bitter it is. You're talking less than 100 parts per million to get that. It's dirt cheap. It's easy to add. It covers your butt for liability reasons, for lawsuits. This is us taking efforts to make sure our product is not used in a way that harms the user, even if it's abused. I think that you might be hard-pressed to find a place that doesn't put a bittering agent in. Why not just leave him? She had the money. This gets in a little more into her mindset that I don't think we'll ever have the answers to unless she speaks out. Selena K gifted 5 memberships. Thank you, Selena. Man, Griffin, I'm sorry. I'd heard this through the grapevine as well. That's terrible. Hope you all are doing better. I hope this this resolution can bring a measure of peace and to the family. So. Old antifreeze from before they started adding stuff to a car is possible. I don't think there was testimony that he did a lot of car repairs, was there? He was more of bikes. He was fixing up bikes and garage sailing. Probably buying bikes and fixing them up and maybe selling them or giving them away. Looks like we're back here. Judge is back on the bench. He's got his bed.
Your Honor, we're back on the record with case on trial and jurors are lining up.
Very good.
I love this clerk. She's amazing. I think she probably used antifreeze. We've got the color change that happened. We've got the color change. We've got the quantity of the poison is higher than can be achieved by mixing in Rain-X. Even though Rain-X has some of the ethyl glycol. It must have had to have been antifreeze. Christina, thank you very much. 5 more gifted memberships. Y'all are turning green rapidly. Thank you for your generosity, Christina. This could be why the number of poisonings has not gone down. Because you could possibly swallow it before. I mean, you can swallow a deadly amount of this poison before you're mentally even think, oh, that tastes off. Because so much of our what we expect to taste is based on our familiarity with the product before. Our eyes, we look at it, it looks right, we take a sip. And we've swallowed it before it's, registered. Thank you, Rebecca. The paper shuffling you're hearing is the judge reading flipping through the jury instructions, which he'll be reading in just a moment. It's a double. I'm counting that one as a double. I'm not going to miss that part of this trial.
I just got brought some tea.
We're going to hit 1,000 before the jury gets in. Arizona, California, Georgia, Illinois, Maine, Maryland, Massachusetts, New Jersey, New Mexico, Oregon, Tennessee, Vermont, Virginia, Washington, West Virginia, and Wisconsin all require bittering agents and antifreeze. Uh-oh, here comes another. It's building. You can hear it.
All good, Maddie. Bring them right over.
All right, for the juice.
Did I get all the counter right? 929. The judge is coughing. He's about to go into a long read, so we'll get a few more coughs from him.
Jurors, you've all been provided with a copy of my written jury instructions. So I see all of you have them in your hands. Before I begin, I just want to make a few observations. First, I'm going to read these instructions to you verbatim. I do that with an understanding that that can be a fairly stupefying experience. But I do that because under our rules, if I read the instructions to you verbatim, I'm permitted to provide you a written copy of them. And so that's why I have to stay completely on script. That's why you're able to have a written set of instructions. Second, with respect to those instructions, I do my very best to proofread them and catch all typographical errors. I hate the thought of my work going to a jury with some typos, but inevitably, as I read the instructions, I spot some. And if that occurs, you will typically see me correct them on the fly. Finally, there are a number of headings and subheadings in these instructions. I don't read them. I read only the text. But the headings and subheadings are available to kind of organize the material. And during your deliberations, if you wish to find some portion of the instructions, it may make it easier for you to do so. So with that, we'll see how I'm able to proceed, but we will proceed. Jurors, thank you for serving on this jury. Jury service is a very important part of our democratic self-government. You are responsible for upholding the law and our principles of justice. That is what you all promised to do at the start of this trial when you took your oath as jurors. You must carefully consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt the single charge that is before you. The final part of this trial will take place in 3 steps. First, I will give you instructions about the law for the specific charge in this case. Then the attorneys will make their closing arguments, where they will highlight the evidence that they think is important and argue in favor of the conclusions that they ask you to reach. After the closing arguments, I will give you general instructions that apply in every case. 4 of you will then randomly be selected to serve as alternates. The remaining 12 jurors will then work together in private in what we refer to as deliberations to reach their verdict. Please pay close attention to my instructions. All of my instructions are important, and you must follow all of them, even if you do not agree with them. To make sure that I give you the instructions accurately, I will read them to you. You've each been given a written copy so you can read along as I deliver them if you choose to do so, and that is up to you. And you will have your copies of the instructions with you during deliberations so that you will be able to refer to them at that time if you wish to do so. If you do read along, read along right now as I deliver the instructions. I ask that you not skip ahead. Rather, please read each line as I deliver it orally. I will do my best to make sure that the instructions I now give when speaking match the written instructions. If there's any difference between what I say aloud and what the written instructions say, please follow what I say aloud. I'm now going to address the fundamental constitutional legal principles that apply in this and all criminal cases. In doing so, I will be repeating and to some extent expanding upon what I told you during the impanelment process and in my earlier instructions just prior to the opening statements. The defendant, Judy Church, has been charged with the offense of murder in the first degree of Leroy Fowler. I will refer in these instructions to Mr. Fowler either by name or as the deceased. Every person who is accused of a crime is presumed to be innocent of that crime. The defendant, Miss Church, is presumed innocent of the charge that has been brought against her in this case. Thank you. That means that you must consider Miss Church to be innocent of that charge unless the prosecution has proved beyond a reasonable doubt through evidence presented during the trial that Miss Church committed the offense. I will explain what I mean by reasonable doubt in just a moment. As a defendant in a criminal case, Miss Church does not have to do anything to convince you that she is innocent of the charge against her. She does not have to explain anything. Miss Church does not have to testify, call, or even question witnesses, or provide any evidence at all because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charge against Miss Church beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Miss Church's guilt, then your verdict must be not guilty. You may find Miss Church guilty only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. And you may find Miss Church not guilty only if all 12 deliberating jurors agree that the Commonwealth has failed to prove the charge beyond a reasonable doubt. In other words, as I will discuss again later, regardless of what your verdict may be, it must be unanimous. You have observed that the defendant, Miss Church, did not testify at the trial of this case. As I told you during empanelment and again in my initial instructions, she had an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Again, it is not up to a defendant to prove that she is not guilty. You may not assume or infer that Miss Church's decision not to testify suggests that she is guilty of any crime. Simply put, that decision by her is not evidence of anything. The fact that Miss Church elected not to testify is in no way to be regarded by you as involving the question of her guilt or non-guilt as to the charge against her. You may not draw any negative inference from that decision, so you are not to discuss it or consider it in any way in your deliberations in the jury room. You must determine whether the Commonwealth has proved its case against Miss Church based solely on the testimony of the witnesses and the exhibits and evidence in the trial of this case. Let me just stop for a moment. It just occurred to me, thinking about the evidence in this case, counsel, that you may not have, we may not have read to a jury stipulation that I think counsel had entered into. Is that correct? We discussed it yesterday afternoon.
Read it or not, Judge. I can do it.
We did not, but it's part. We all agree it's part of the evidence, correct?
Correct.
All right. So that is marked as what exhibit?
66, Your Honor.
66. All right. And it need not be read now, but I just will tell the jurors that Exhibit 66 was a stipulation that counsel have entered into in this case. I meant to read it to you this morning. I did ask counsel to remind me. We all forgot. But I want to make sure that you read that stipulation and understand that that's part of the evidence before you. Getting back to the instructions on page 6 under the heading Proof Beyond a Reasonable Doubt. As I have now repeatedly told you, the burden is on the Commonwealth to prove beyond a reasonable doubt that Miss Church is guilty of the charge made against her. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. That is found not guilty. It is not enough for the Commonwealth to establish a probability, even a strong probability, that Miss Church is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of Miss Church's guilt to a reasonable and moral certainty. A certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. The Commonwealth has charged the defendant, Judy Church, with murder in the first degree. There are two different degrees of murder: murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on two alternative theories: murder with deliberate premeditation and murder with extreme atrocity or cruelty. To find the defendant guilty on either of these theories of murder, you must be unanimous. That is, all 12 of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict form as to each theory on which you would agree unanimously. I will discuss the verdict form with you more fully later. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these two theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I will begin by instructing you on the elements for each of the two theories of murder in the first degree. I will then instruct you on murder in the second degree. I start with the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt each of the following three elements. First, that the defendant caused the death of the deceased. Second, that the defendant intended to kill the deceased. That is, the defendant consciously and purposefully intended to cause the deceased's death. And third, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I will now discuss each of these requirements in more detail. The first element is that the defendant, Miss Church, caused the death of the deceased, Mr. Fowler. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill the deceased. That is, that Miss Church consciously and purposefully intended to cause Mr. Fowler's death. If you have a reasonable doubt as to whether the deceased's death was accidental, because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find the Commonwealth has proved this element of intent to kill the victim. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from the decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. Next, I will define the elements of murder in the first degree with extreme atrocity or cruelty. You shall consider this theory of murder in the first degree, regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove each of the following three elements beyond a reasonable doubt. First, that the defendant caused the death of the deceased. Second, that the defendant either A, intended to kill the deceased, or B, intended to cause grievous bodily harm to the deceased, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of the deceased. This is the same as the first element of first-degree murder by deliberate premeditation. As I've already explained, a defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant, A, intended to kill the deceased, or B, intended to cause grievous bodily harm to the deceased, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, this second element has three sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to the deceased. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that the death of the deceased would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the deceased's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether the deceased's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant created a plain and strong likelihood that death would result. The third element is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in any taking of a human life. You must determine whether the method or mode of a killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's action in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death of the deceased with extreme atrocity or cruelty, you must consider the following factors. 1.
That was a rough one.
Whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2. Whether the defendant's method or means of killing the deceased was reasonably likely to substantially increase or prolong the conscious suffering of the victim. Or 3. Whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the three factors I have just listed. Turning to murder in the second degree, in order to prove a defendant guilty of this, the Commonwealth must prove each of the following two elements beyond a reasonable doubt. First, that the defendant caused the death of the deceased, and second, that the defendant intended to kill the deceased, or intended to cause grievous bodily harm to the deceased, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the requirements of proof for murder in the second degree are the same as for murder in the first degree, with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity or cruelty. As to the two common elements, the same instructions I have already provided regarding those two elements apply as well to the charge of murder in the second degree. I'm now going to see counsel very briefly at the sidebar, and then I will have a few brief remarks about the closing arguments, and we'll proceed accordingly.
All right, we got the cough right at the end. We're at 962. Two of the coughs were from Judy, as a matter of fact. First time we've seen her cough during the trial. I have, with permission from family members, I've received some pictures that we'll be showing after the closing statements.
Jurors, why don't you stand up for a moment and stretch, shake out the cobwebs a little bit?
In these courts, sorry. Oh my goodness, everyone's just coughing. In these trials, in the courtroom, it's very different from a funeral. When someone passes away, a lot of times we focus on the best aspects of their lives. We look at the parts where
we're now going to proceed to the closing argument stage of the trial. This is an opportunity for each of the attorneys to sum up for you the evidence you have heard and suggest to you how you ought to view the evidence and what inferences and conclusions you should draw from it. If you choose to take notes during the closings, you may do so. If you do take notes, I suggest that you draw a line across your notebook page so that you are reminded that everything that appears below the line is not evidence and should not be considered as evidence by you. The attorneys will do their very best to accurately relate the testimony you have heard and the content of the exhibits that have been admitted into evidence. But if anything either attorney says conflicts with your view of the evidence, you are to disregard it, as it is your collective memory and view of the evidence that controls.
No baby yet.
Bear in mind as well that it is impermissible for either attorney to express any personal opinion about the evidence or about the credibility of any witness. I do not expect that either attorney will do so. But if either attorney uses any phraseology that might suggest that he is expressing some personal opinion, such as the words, "I think," you are to regard the comment as one solely suggesting how you should view the evidence, and not as an expression by the attorney of his personal opinion. Because the Commonwealth bears the burden of proving the charge it has brought against Ms. Church, Mr. Camilio, the prosecutor, went first at the opening statements phase of the trial, and he will go last now. So you will first hear from defense counsel, Mr. Norkunis, on behalf of the defendant, Judy Church. Mr. Norkunis, the floor is yours.
Thank you, Judge. Good morning, ladies and gentlemen. I'm here now as we have come to that conclusion of the case.
I'm going to have to crank the volume.
Each side gets to argue the evidence and tell you why their position is the correct position for you to present when you return a verdict in this particular case. You've heard from Attorney Scully, you've seen Ms. Morrissey. In this particular case, we represent Judy Church in these proceedings. Two issues, two words that we began the case with, and I think are important throughout. We talked about color and we talked about taste. We had some presentations relative to that, and I'll get to those in a moment with you. He, Leroy, did what he wanted, and you don't tell him what to do. You just don't. This was Judy Church in a statement to the police when she was talking to Trooper Williams and she was talking to Detective Verney on November 14, 2020. Judy Church did not kill Leroy Fowler. Judy Church did not murder Leroy Fowler. Now, the court has set out for you the law that it gets applied in this particular case. I would just like to highlight as I'm beginning again what some of that is. The very foundation of our system of justice in which we operate. It's the bedrock of which our entire system is built. There's reasonable doubt. This isn't just a technicality, and it's not just a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove each and every element of the charged crime, in this particular case, murder, beyond a reasonable doubt, that is to a moral certainty. Those are powerful words. They're not just legal jargon. They are your mandate. They are your obligation. They're your community's protection against injustice in our system. Now, what that means is that at the end of the case, where we are, at the end of this trial, when you have the charge by the court and you are deliberating, if you think, you know what, maybe that's true, it might be true, then you have to vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true, even if very likely true, your vote still must be not guilty, because none of those standards, none of them, might be, could be, possibly, very likely, none of those meets the extraordinary burden of what beyond a reasonable doubt to a moral certainty means within our criminal justice system. Now, this case revolves around the relationship of the church in the Leroy Fowler.
Ouch.
And the...
Somebody's collating a book in the background. I don't know
Judy
what's going on.
Church, a mother, a sister, a homemaker, an educator. She laid those all out for the police when she gave her second statement on November 14th. She told Trooper Williams about her long career as a fourth grade teacher in Middleton, Massachusetts. She was married when she first encountered Leroy Fowler. He came and he rented a room or unit from her at their home in Salisbury. Soon, they became a couple. They were in love. Husband left. Husband, I believe the name you've heard was Rusty. He left. And at that point in time, then, I might show you this. These have been introduced as exhibits in this particular case. The next one, please. In 2012, then, Judy and Leroy set up a home, and they started to create a life together. Judy had financial security. She had the house. She had the full-time job. She was healthy, vibrant, and smart. Then they cruise along in that same mode. And then in 2016, 2017, someplace in that time frame, Leroy began a second relationship with a woman named Barbara Randall. Also about that time, and you have the medical records of Leroy here, he started having a number of medical issues. You have his medical records from 2016 to 2022. The health continued to spiral downwards up and through November 14th, 2022. And again, you'll have those available to you. You can see what they set out for you. Physically, at times he had chronic pain syndrome. He had a pacemaker. He had Achilles problems. He had stomach issues. Mentally, he had depression. The records show he had bipolar disorder and anxiety. And at that point in time, the evidence is being presented to you. He was not working. He was on perhaps Social Security disability, but he had no financial independence. And what also is indicated in there, he was polysubstance abuse issues. He was using cocaine. And an emerging issue, perhaps, with alcohol from some of the evidence that you've heard. At one point in time, Leroy had a temper, and at one point in time, he got into a physical altercation with Barbara Randall, and that was in the summer of 2022. Pulled her hair, threw her to the ground. Things were not getting better for Leroy at that time. He had some blackouts that had been reported, and and his position seemed to be getting physically worse. Over the years, as the couple progressed, Judy had bought 2 motorcycles for Leroy and a pickup truck. He did become dependent upon her as his principal source of income. But the actions of Leroy Fowler were somewhat consistent. You had heard from Michael Hawkins. Michael Hawkins told you that his mother was named Julie Hawkins, and Leroy had been living with them. Then at some point in time, when he had met Judy, Leroy moved out on Julie Hawkins and moved in with Judy Church. And then he would be, according to Michael Hawkins, come back for visits was the term that he had used. I would submit to you there would seem to be a particular pattern of the way Leroy Fowler was leading his life in terms of associations with women. And then he takes on a life of his own. His agenda was the agenda that he made as once he became, in this 2017, I believe the evidence was from Barbara Randall, that he began an association with her. And it was an association where he went over a house, stayed there. You can believe they were living as a couple. It's reasonable to infer from what you have heard. At the same time, he's still living with Judy Church. And at that point in time, and I think there was some indications from some of the evidence, obviously Judy Church was hurt. I'm assuming at some point in time, Barbara Randall was hurt. He's splitting his time between both. He's abusive, therefore, emotionally to both women at the same time. There is no particular, they show flashes of anger but they blame each other. Neither one of them is blaming text messages you have available to you, is blaming the Leroy. They had even came out with nicknames for each other, and you heard those from the testimony here. I won't repeat those here today, but it denigrated to that situation. Again, the person that was causing all of this, they didn't share their anger at, they did it towards each other at that point in time. Judy would channel her anger at times, and you have a couple of the journals, they're undated, but she would journal her anger about what Leroy was doing, a way to get rid of your hostility without taking out any action against the person. She would put down what she saw and what was there.
Or to plan it in detail.
But Judy constantly expressed her love for Leroy, despite what was happening to her, and it does get angry at times. Tammy Carbone, Leroy's sister, testified she became friends with both women during this period of time. She testified Leroy did not have the means to pay for his own life, and he had his health problems. As previously mentioned, Leroy III, the son, was out trying to give some work to his father. I think he said he gave one construction job to them. The important aspect of that is he still could go out and do work. You heard about, through the statements of Judy Church, which we'll get to in a moment, to the police, that Leroy was doing work around their homes, that he was building, trying to build a floor underneath. He still had his, he was still active physically. Michael Hawkins took him to work on a grow facility for 3 days up in Vermont. And he was active as physically there as well. Get up there. He indicated that at some point in time, Leroy III, that he even had a restraining order against his father in 20 and 21 due to physical issues that he had encountered with his dad. Leroy III, the son, also had a relationship with both Judy and Barbara Randall. There's crossing roads at all times. The years move on for the triangle that is composed of Judy Church and Leroy Fowler and Barbara Randall. Nothing of any hostility between the women themselves, physical hostility. There are down times, there are messages expressing feelings, there are partial breakups, but Judy continues to express her love for Leroy. She gets very hurt, she indicates, when at one point in time, when she sees Barbara sitting on the back of a motorcycle that she bought for Leroy. And at that point in time, she went out and bought him another motorcycle instead. Now, when you move into January of 2022, the couple, Leroy and Judy Church, go down to Florida. They buy a home. There's a deed here showing that they actually bought the home in Florida, and it's under both of them. It's under both their names, tenancy by the entirety, which is normal when there's a couple together within it. And Judy is pushing Leroy to join her and come, and they're going to move to Florida. It gets delayed, and finally in mid-November, they're packing up, they're going. You saw the house, pictures of the house. Everything seemed to be in disarray as they were packing up and getting ready to leave in the house. They had bought a van. William Eaton talked to you about a second van they were looking at to get so they could move to Florida. In that mid-November time frame is when all of the dreams of Judy Church are coming true. Barbara's going to be behind. Leroy Fowler is coming with her. They've got a residence, a home in both of their names in Florida, and they're moving there. There are text messages of evidence showing that Leroy and Barbara had ended it, the hostility between them, the words that were done. I believe they were from November 5th or 6th, but you'll have those with you in the jury room to look at within this. That Judy, when she's talking to the police, says that she believes when they're down there, Leroy can be drug-free because she believes, she has no basis for it necessarily, but she believes that Barbara Randall is the source of Percocets for Leroy. And now in Florida, the drug issue would be left behind, and they will be all set. Now, Leroy had particular drinks. Everybody said he had a sweet taste in what he liked to drink. He liked to drink Fanta, orange soda, and he liked to drink fruit punch, red, Powerade, and coffee fraps or milkshakes made for him by Judy in her blender. At some point prior to 2022, it became a family joke that originally started perhaps by Leroy, that in giving the milkshakes to Leroy, she was trying to poison him. Now, if you jump forward to the police search, they take the blender out of the house. They don't do any testing on that. But that was the position that the family had, that he was getting poisoned through family milkshakes made in the blender of her home. They seize the blender, but they don't touch it. They don't test it to see if there's anything there. Now, in the weeks leading up to November 11th, family and friends speak and see Leroy and express opinions about how he feels and what he looks like. Now, Michael Eaton said he talks with him about the van, sees him about a week prior regarding the sale of the van. He said he looked fine, sounded fine, and seemed to be happy about and speaking about moving to Florida. Now, the day that the government says that Judy Church stepped forward to murder Leroy Fowler Sr., she did so by putting ethylene glycol in a Powerade bottle. All of the evidence of that time shows that, the dreams of Judy Church have come true, that everything is working well at that point in time. The government has no evidence in this particular case, direct or even circumstantial, that things were a rise on November 10th, November 9th, November 11th, and yet they want you to believe that she purposely and deliberately set out to murder him. not harm him, but murder him at that particular date. The circumstantial evidence supporting that is so minimal, ladies and gentlemen, in this particular case. Now, Leroy is up most of that night, according to what Judy says, and we'll get to her statements to the police in a moment. And he has a consistent message, and he is, and I'll go over this probably several times, he's doing text messaging. So I'm absolutely sure going at text messaging. They are somewhat, pornographic going forward, but there's a consistent message from 1 a.m. through 5:30 a.m. So the thought process is working here, and then he's doing it on a cell phone. Everybody has done that. And what is your keyboard on a cell phone? 1 inch high by 2 inches wide. And for most men, larger hands, larger fingers, you've got to know what you're doing, and the message goes through. It's possible some of those, there's some misspellings or misstatements on it, but it shows a consistency of mental alertness, physical dexterity in this particular case. Why is that important? Because you've heard a lot of evidence in this case about what ethylene glycol does. Ethylene glycol has a timeline. Even with Mr. Crouch here today, statements from and questions from Mr. Filio, it's a timeline. There were 3 stages they talked about. The doctor from Mount Auburn also told you about the half-life of ethylene glycol and what happens when that is consumed. And jumping ahead into Mr. Crouch's statements to begin with, he talked about the quantity that would be necessary for a person to consume to be able to have, considering those other factors, ethylene glycol. You've heard words metabolizes, become acids, anion gaps, and asmolar, whatever. The ethylene glycol disappears, and that's the toxic substance come in, but it moves quickly through the system. He had 28 grams in his system still at the time he went to Anna Jake's hospital in Newburyport. That again, I would submit to you, when you analyze the timeline, it's consistent with someone that's doing it themselves in the evening. He would have to have consumed to get to that, somewhere around 2 or maybe a little more 20-ounce Powerade bottles itself. Whatever may have been in them and however it got into them. Now, at some point in time then, Anna Jakes decides that they can't treat Mr. Fowler as he's there. When you first look at what happens, you had the videotape of the officer that responds to Laria and the EMTs and the fire department that gets there. And what do? They come in and it's clear and obvious that they believe he's ODing. They're in no hurry. They're talking to him. They're doing something. The officer took the stand to counter Mr. Lemke, one of the EMTs, who had said that Leroy said to him something in the neighborhood of either I took 2 perk 10s or I took 10 perks. But he made a statement to him. The officer's presentation is, well, I didn't hear it. When you look at it, what you're going to see is, as where I am here, he's outside the door. The 2 EMTs are inside. Judy's in the bed talking. They're bending down to hear the man. This officer said, I didn't hear it. Because you didn't hear it, it didn't happen. Mr. Lemke was certain it happened. He said it. And I believe he told you that he repeated it inside the ambulance itself. What's important about that is, he didn't say, it's what she made me drink. I was poisoned. It's what it was the liquid that I drank. It was the milkshake. None of that came in at that point in time. A critical stage of his life at that point, and he's not saying anything other than he believed it was something that he took on his own. And I think that is absolutely critical. What happens after that is it seems to take on a life of its own, the investigation, not driven by investigators, but put together as the family believes that something happened because Leroy said over the years, I think Judy's poisoning me. Part of it also is you've heard about the timeline, and you've heard about what happens if you get to someone within who has ethylene glycol poisoning, and you get to them within a reasoned period of time, maybe they're going to be pretty good. He sits in Anna Jake's 12 hours, I think it was what the nurse said. And then at some point in time, he gets moved to Mount Auburn. Mount Auburn decides they cannot do it. They do a dialysis, but they can't really help him anymore. And then they send him over to Beth Israel.
He's been speaking for 22 minutes so far.
If I can sneak by here for a moment.
He's also at the part in the space in the courtroom that has the least mic coverage. So we've had to crank the volume up, which makes everybody else's coughs louder, just so we can hear this defense attorney. Hopefully the prosecution does a little better.
Within the records you're going to see of Beth Israel Hospital itself, and you'll have those with you and be able to read them. There is the statement that I had the ME read to you, in which the doctors treating him, the team treating him, said this is an unusual case. There is an issue relative to whether he actually has ethylene glycol poisoning or what is causing his death. He ultimately dies of a stroke in this particular case. The family now gets together, the family, and what you have within that is you have Tammy Carbone, you have Leroy III, and you have Michael Hawkins all together and go to Mr. Eaton's house, and they call the police to come there. How unusual is that? The police are going to go talk to the family all collectively together at the house. As a result of that, the family tells them about the joke. She's been poisoning me. They figure, that's it. We know what we've got. Let's go. Off they go to speak to Judy Church herself. That's the interview that takes place on her own property. She meets with them. You have the video. You're able to see that. She's not expecting the police. She comes home with a pizza. She's genuinely concerned and afraid when they tell her, why are you here? And she believes they're going to tell her that Leroy has died. And she's upset relative to that. And they say they're there to investigate what has happened to them. I believe it's Trooper Williams who tries to assuage her emotional state and say what we're trying to do is just find out how this came about, what happened relative to this. She tears up several times in talking about him, walks the police around, takes them to where he had been working again, she said, that week, and what he had been doing. I think she said he was trying to replace a floor at that point in time. In the house, in the cottage that was behind the house that they had. Now, there's a second interview done with Judy. And when that second interview is being conducted, they are also at that point in time conducting a search of Judy Church's home. And as Attorney Scully pointed out so ably to you, the search seemed to be cursory. How many items weren't even looked at? How many items weren't even examined within the context of that house itself? And the essence, I think, of that is that at some point in time, after the interview with Judy Church, the Trooper Williams goes back to the house, goes into the room occupied by Mr. Fowler, looks around, and there are several containers of Fanta soda, which was his second issue that they had, and he takes one. Arbitrarily looks at it and says, I'll take that one. And even he couldn't explain why he did that. He just thought he should take one out of it. The room where he had been the night before, and he had spent considerable time, and he had been doing his texting. And then that goes off to the lab. Ultimately, both matters go off to the lab at some point in time in December out at NMS. And you heard the gentleman from NMS come in and testify. And they found ethylene glycol in the solution sent from the Powerade bottle. And again, this was a fruit punch, a red fruit punch bottle. And yet what they find, and they find it in the recycling bin, is a fruit punch bottle that's orange in color. And that's the reason it gets their attention. It's orange in color, and they assume, and obviously it's not fruit punch. And again, as we had said to you before, and we have repeated throughout, color and taste are two huge criteria for anybody. Anything you pick up, you go, you get a glass of milk, and all of a sudden you take a light sip, and it's sour. I'm not drinking that. I'm sorry, I'm not doing that. You look at something, it's the wrong color. You've ordered a root beer. It comes and it's orange. What are you going to say? That's not my drink. You can't do that. If you are consistently over the years drinking a red drink, you're going to look for it to be red. If it's a different color, I would submit the average person isn't going to consume it. You don't know what that is.
Some little lighting in the house at night.
In relation to, did that particular item taste bitter to Leroy Fowler? Now again, the government chooses not to test for Beatrix. The NMS gentleman said, well, we don't do that because we don't advise it to be done. Apparently it's a test, I don't know, costly or whatever. We had it done on behalf of Judy Church. We found a lab that would do that, and they did it. NMS certainly could have had the same capabilities or have done that. It certainly leads an investigation into why would this happen? Why would someone with that? A number of the witnesses at the request of Mr. Camilio said, well, statistics show people are still doing it. If people are self-bent on hurting themselves, yes, they could still do that. But it's put in there, and Massachusetts has a statute on it. It's put in there for a particular purpose, if nothing else, to alert you for what you're consuming. So the color and the taste are wrong in the bottles that they find where the ethylene glycol is there. Interestingly enough, the other bottles they pull out of Powerade, they don't do any testing on. Why? We don't really know at that point in time. Now, while all of that is happening, Judy goes in and gives a statement to the police. Leroy had passed away. She had done that. She comes to the station voluntarily. She's not under arrest. She's not being forced to go there. She waves, and you've heard that. You hear her voice. You hear her tone. You see her body movements. All of those things everybody takes into account when you're seeing if somebody is truthful or not truthful. What are you doing? How are you doing it? Where are you looking? And so you can see all of that. She provides her phone password to them so they can get into it. As we all know, Apple doesn't let you get into the phone no matter what happens unless you have a password. Now, she provides her email address so that can be searched. When she's asked whether they will find anything about antifreeze on her phones, she says no. And they don't. Or it would have been an exhibit, certainly, in this particular case, if that had come forward. Among other things she says Leroy was her world. They lie and suggest her fingerprints will be on an antifreeze bottle. They found at her home. They try and trick her, persuade her. What is she going to say? For an hour and a half, she's there and talking. They didn't find any antifreeze at the house. They never found antifreeze at the house. So I'll get to discuss with you in a minute. They never found a source for it, for whatever the ethylene glycol was that's in that Powerade bottle. But they're trying to trick her, but she's being truthful. And she confidently says her prints won't be found on it. They don't have it, and they don't. And interestingly enough, of the Powerade bottle that's here in this particular case, we've heard much about DNA and what's found on DNA on that, which I'll get to in a moment. There's no fingerprints of Judy on that. It's in the recycling bin. You would expect it probably would have been. But nothing. They don't find that on there. Now, they ask her why the Fowler family is blaming her. They put direct questions from her that you, as jurors, trying to determine what may happen in a case, would have probably wanted to have placed before him. She explains that they've all taken the old joke, as I've told you, and they've run away with it. She tells the police that they're all putting the blame on her, but it isn't her. She repeatedly says, I did not kill that man. I love that man. Now, you can ask yourself, if Judy did poison Leroy, then why would she joke about it with Tammy while he was in the hospital?
I need you guys to count the cost
Remember,
a
there was
little bit.
LOL, laugh out loud. I'm going to bring him a poison milkshake. And Tammy says, maybe I'll bring him one too.
Update for just a minute.
That. And remember, she's a very smart lady. They bluff, the police bluff, and they try, and what if we test the Ninja machine, the blender? She says, go ahead. They do take it. It's in the photos you saw of what was taken by the search. And they never test it. So they're challenging her left and right, and she is 100% successful. After an hour and a half of intense grilling by 2 officers, she has stayed with her description of what took place and why it took place. Now, in the DNA itself, as to the significance of that in this particular case, you've heard about transfer, secondary transfer. I've touched that rail several times throughout this trial. My DNA could go home with some of you who've reached over and touched that yourselves on it. The issue about a cap, I just put my cap here. Wasn't that going to pick up DNA? The issue is, why would it be on the lip? Now I'm going to put the cap back in the bottle, as most people do. If you haven't finished it in one, you always put the cap back on. Take it off again, I put it on something else.
Yeah, you're going to die. You're going to
I
get
put
infected.
it back on. Transfer. Whatever DNA was there, is now on the lip of that bottle. That's not any type of miracle. It's her house. Her DNA is everywhere. How many years have they lived there? It's everywhere. Leroy's there too. Now, was Leroy's not on the lip of the bottle? So the only person that was drinking ethylene glycol was Judy? No, that was a transfer issue. The other aspect you can see many times, people will take a slug of the water. You might do this. You might touch someone after that. I've done this. You've got my DNA. There's no way that that DNA has any evidence of any merit whatsoever in this particular case. I think, and I would submit to you, again, the issue within the context of this case, it's circumstantial evidence. Circumstantial evidence, I would submit to you, is never going to show you proof beyond a reasonable doubt on the most serious charge we have in our judicial system. There is nothing here that would put that together. Well, the first thing you would need is, if the government is correct, you'd need a motive. Why am I going to kill you, would say Judy. Why is Judy Church on November 11th, 2022, want to murder? Not harm, not kick, not incapacitate, murder Leroy Fowler. Well, wait, Barbara's going to be left behind. That could be a reason. Maybe he was going with Barbara. No, wait. There's no evidence of that. It's just the opposite. He's told Barbara goodbye. Well, maybe he's going to move out with someone else. No, they're going to Florida. They put a house in his name in Florida. So he's got some financial gain to go and make and do, and her life is going to be successful. There's just no motivating factor here. Everything has come together finally for what should take place. Judy Church was angry at Leroy. Move out. It's my house. I get a restraining order and you're gone. How about 2019, he's been with Barbara for a year. Would you be angry and now want to kill her? How about the statement of John Haywood to show you the reach of the government and the reach of the family? 2 years later, on this issue, he comes forward. So I was in a bar, talked to him for 4 minutes, and Judy said, if he ever cheats on me, this is 2020, if he ever cheats on me, I'll poison him. Let's see. He was cheating on her all of 2018, all of 2019. When was that in 2020? How does that statement make any sense? And he tells it 2 years later, and he's related to the family. That's the overreach that the government has in this case for you. The significant overreach. So motive, we don't know. Now, how about ethylene glycol? Had anybody ever heard of ethylene glycol if you weren't working in the automotive industry beforehand? Trooper Williams, what did he have to do to learn about ethylene glycol? He went on Wikipedia. Isn't that how he thought he could charge her? Because he's found out ethylene glycol is this on Wikipedia. But I think of more interest is the medical examiner. He's a doctor. He's coming up with causes of death. He's never had one before. What did he do? He said he went onto the computer and looked up Wikipedia. What do they find on Judy's phone? What searches? Where was she finding out? How am I going to kill him? Was she looking for cyanide? Was she looking for other substances? And it finally came up with ethylene glycol? No, nothing. Nothing. So if these very learned people, one in the law enforcement, one partially ME, and then even the NMS scientist said to you, he's only had one case ever, 2000. He had to look up some stuff online. So how's Judy finding out? One, do you get on to CVS and they got a special going? Over here this week, there's ethylene glycol. Maybe it's Market Basket. Where do you get it? Do you get it pure or do you get it with Beatrix in it? How would you get Beatrix to put it in if you didn't do that? I mean, there's somewhat of an absurdity in terms of the overreach. They have never, ever been able to tell you a source that they say of the ethylene glycol. And you wonder, why do I have that up here? And that's introduced as evidence. And there's multiple pictures of another bottle of it. Because this is what they originally thought it was. This has no merit as evidence whatsoever in this case, except it was found in the kitchen of the house. None. It's not this. That's the type of distraction that's ongoing here. You're probably looking at this since I started giving this speech. What is he going to do with that? Why is that there? Because it has no value whatsoever. But it's to try and convince you that someplace in that house, she must have had something like this. We just never found it. But it's not there. So we don't have a motive. We don't have any planning. We don't have any ability to pick up whatever it is that's supposed to be there on the most serious charge of our judicial system as to why this lady would have done that. Now, just a circumstantial case is not, in terms of what is here, is not the proof beyond a reasonable doubt to a moral certainty equating to one of the most important decisions you would make in your life. Again, if Judy didn't want Leroy, get out, leave 2019, 2018, 2019, 2020, 2021, early part of 2022, and wait till everything is perfect, and now I'm going to go out and do something that most people don't know anything about and find out how to effectuate this. Now, one thing that I think has to be considered is the videos. There's 13 of those small videos, a minute apiece, that was taken on the early morning hours of that. The government wants you to view them as Judy somehow enjoying the suffering of Leroy. She told the police this was something he had done before when he OD'd on drugs. It's something that's not uncommon for people to do when there's people having some sort of problems with a family member, and you want to show them what their conduct does. So she takes them and she keeps asking him, that 29 minutes, what happened? What did you take? Do you want me to call an ambulance? Finally, when he says yes, and when the police talked to her about was there any delay in the ambulance, she said he didn't want to go to Anna Jake's. He didn't want to have the hospital an ambulance take him. But so she waited until he said that. And if it was in fact, as everybody at that moment thought, the type of tape you could use, you get to Florida and you say, let's not ever have this happen again. Let's not get involved in any type of drug issue. There's no enjoying what your discomfort is in this particular case. Ultimately, he doesn't have any physical issues. He's not cutting himself. He's not bleeding. He's not getting bruising. I think two different doctors told you that in this particular situation. So there was a purpose. There was a method. Because again, they're leaving. And then when he gets to the hospital, she's there. She's the person that goes. And again, relative to the dissatisfaction of the family, they're really, really upset that she didn't bring them and notify them before they have their meeting at the house. Now, again, your mission is not to try and figure out what happened to Leroy. It's not why we're here. You have only one function, and that is to determine whether the prosecution has proven its case against Judy Church beyond a reasonable doubt as to each and every element. Again, it's not a maybe, it's not a probability, it's not a possibility. It's to a moral certainty. And remember, this case is loaded with reasonable doubt. Pieces of the puzzle. Mr. Scully, Attorney Scully, told you about that when we began. It's like a puzzle. And the government is trying to fit all the pieces in, but they're trying to put some square pieces into round holes, and they don't fit in what we have here. Now, it's impossible to think that Leroy Fowler wouldn't have noticed the color. It's bright orange on those as I've displayed those to you. It's impossible to think that he was drinking was not his usual red fruit punch. It's impossible to ignore the bittering agent we would submit to you that's in there. When asked why the prosecution didn't test for it, Sergeant Williams didn't have a good explanation, really. He relied on a Google search about it. They did test for fingerprints, none found. They did test for DNA. We've gone over that relative to this. They generated 5 profiles. What does that really mean? The search of Judy's house was totally unorganized and centered only on one thing. She did it. We don't really have to look for anything else. Let's go. And again, watching what took place with Trooper Williams when he comes back and he goes into the back bedroom, because Judy told him that Leroy was beforehand. He looks around, sees a couple of Fanta cans, and decides, I'll take that one. That shows you exactly the effort that was being taken in this particular case. Each of these helps you determine that there is reasonable doubt in there. We saw photographs that were never collected or tested. Multiple Powerade bottles. How about we test more of those? Multiple orange Fanta cans. How about the can that went out to the NMS? Well, there was some sort of interference because there was some other substance. This is a chemical lab testing. There was some other chemical in there. We didn't know what it is. Well, you're a chemical lab. Why don't you test for that and tell us what it is? Is that ethylene glycol? Is that cocaine? Is that something? What is that? Give us something. Nope. We decided not to finish the test, and the government said that we're not going to redo that test. Those are the items in the back bedroom. Is that where more of the 28 grams were coming from? What was in his bedroom at that point in time? We don't know. When she goes to the hospital, Judy's holding his hand. She brings him presents. She tries to stage a birthday party from him when he's in there. If Judy put antifreeze in the Powerade, why would you leave that in your house? She's a smart lady. You could tell by the interview with the police. So it's going to happen, and I'm just going to throw it into the trash. I'm just going to put it not only in the trash, I'm going to put it into recycling. There's no, in that context, ladies and gentlemen, again, it shows you the reasonable doubt, the circumstantial evidence that is an overreach in this case. Again, the Rain Act turned out not even to be linked in this case. They found nothing incriminating in Judy's diaries or notebooks. How about the puppet about Barbara? How many people have done something like that over the years, right? What does that signify? And did we even have a year for that? Was that 2018? And that meant in 2022, 4 years later, she would want to murder Leroy? And the text message about being a Scorpio and knowing what to sting. It doesn't mention Leroy and has nothing to do with him. It seemed to be more directed towards Barbara. They didn't find what they were looking for, so they cut and paste together all these scraps of text messages, photographs, journal entries. It says, here, we think we've got it all together now. If she had something incriminating on her phone, why wouldn't she hide it? Wipe the phone. What did Tom Brady do? He took out the chip and he broke it. Why? How much do you have to know to be able to do something to hide it from on your phone? And again, Mr. Lemke, what he told you happened with him. Trooper Williams, young, smart, but eager to solve the case very quickly, very energetically, and without a lot of effort, right? We got it right here. But the investigation lacks merit in this particular case. Judy and Leroy's text messages, they're all positive in November of 2022. That's when this is happening, 2022. This is not something in September they decide he's going to murder him, but I think I'll wait 2 months. The weather might be better in November to commit a murder than it might be in September. The text messages that are current showing the mental state and alertness. Leroy's texting, again, I've told you that. What is there? Again, the video's somewhat difficult to watch, but she has seen him like this before, and she wanted to show him to Leroy, a big incentive to change. She doesn't delete them. Why wouldn't you delete them if you thought there was something wrong and you had murdered him? Why would you not do that? That would have to be really something that would be on the pale as it would go, right?
Mr. Norkunis, you're out just about 50 minutes.
Thank you, Judge. This is a circumstantial case, ladies and gentlemen. When we began, our clerk, Ms. Draper, told you that Judy Church had placed herself before her country, which country you are. And you represent the best in our judicial system. I submit to you that the only true and just verdict in this case is that of not guilty of the charge here facing Judy Church. I want to thank you on behalf of Ms. Church, Attorney Scully, and Ms. Morrissey for your time, patience, and effort in this case, ladies and gentlemen. Thank you, Your Honor.
Thank you, Mr. Norkunis. Jurors, I'm going to suggest you stand up for just a moment. And in a moment, Mr. Camellia will address you.
Coughs. Oh, my goodness. How many is that? 6. Everyone's coughing at once. 7, 8.
Can you confirm with Mr. Camillo regarding?
Sure.
9. Everyone was holding it.
Right now. Okay. Thank you.
Counting that as well.
You'll know.
All ready? Mr. Camellia.
Thank you, Your Honor. If you see those two cunts that live in the cottage, tell them I have words. You'll recognize those two cunts because you're with one. I guessed it all, didn't I? You're just here and dragged me along to buy gas because you don't want to be with me in Florida. Like that morning in Florida, you baited me with that cunt on the phone to say out loud that you don't want to be there. And when we left so abruptly, it's exactly what I said, that as soon as we got home, you'd leave. And you did just that, even though you promised otherwise. If you don't want to go back to Florida, just say so. If you and I are done, just say so. I'm not going to fork over another penny for you to fuck me over ever again. Because I know that you'll just still drag that skank bitch back with us. You keep complaining about the cold and that you want to go home. I want to be in Florida. You only want to be in Florida or anywhere else with my money. Obviously, I am not the one you want to be with because you fucked me over today too. I started the closing the same way I started the opening, with the words written by Judy Church, the first time in her notebooks and this time in the note section of her phone. The Commonwealth can call witnesses, we can introduce evidence, we can talk about the science. But nobody can give you a better picture, nothing can give you a better picture of the nature of the toxic and dysfunctional relationship that existed between Judy Church and Leroy Fowler than the own words that come out of the pen of Judy Church. She's the one that describes that relationship using those vile words, which I've used during the course of this trial because they're important. In a courtroom, we don't pretend that words don't mean what they mean. We don't say the C word. We use the words that people actually say. In the defense, they won't say it because they know how vile it is. They know how angry it makes Miss Church. They know how much she had to have hated Barbara Randall to use that word over and over and over again. She used it with her friends. She used it with Leroy. She used it with the police. The first time they show up at this house, at her house, not knowing a single thing about Leroy, not knowing a single thing about Judy Church, she says, oh yeah, she describes his other girlfriend as the cunt. This was not a healthy relationship. This relationship was toxic. Judy Church hated Barbara Randall. She hated that Leroy left her to go see Barbara. And it was a horrible thing, right? This is a horrible relationship. Leroy Fowler was doing horrible things, right? He treated Judy poorly. He treated Barb poorly. And Judy, she just hated it. He left her alone over and over and over again. Every time he left her to go to Barbara's house, what he was telling her, what he was saying to her was, you're not enough. You're not wanted. You're not loved. I need more than you can give me. Judy tried to make up for that with her money, right? She bought him she bought him 2 motorcycles. She bought him a second one because she saw Barbara Randall riding on the first one that she had purchased. That's how much she hated Barbara Randall. That's how much she hated their relationship. She bought him a truck. She bought him a house. And no matter how much money she spent, every single time, as I just read to you in Exhibit 46, no matter how much money she spent, she knew that Leroy was going back to Barbara. And she hated it. She snooped on Leroy's phone. She took pictures of their text messages. When the text messages were happy, when Barbara and Leroy were having a good time, it must have been awful for her. When they were fighting and breaking up, it must have made her happy, right? When she saw the video on Leroy's phone of him proposing to Barbara Randall, it must have been like a knife in the gut. God, she hated Barbara Randall. She hated her. She had the voodoo doll that, despite what Mr. Narkunis is not something that normal people do. That people normally do. It's just not. Leroy removed Judy's name, the tattoo that he had over his heart, at Barbara Randall's urging. God, how painful did this have to be for Judy? No matter what she did, no matter what she did, he always went back to Barbara every single time. She had to know, no matter what she did, he was never going to be faithful to her. He was never going to stay with her. Now, it was described during the trial by Mr. Scully as an open relationship. Judy herself told the police, "He cheats on me." She knew this was what it was. She knew this was cheating. This was not an open relationship. This was toxic. This was horrible. It was dysfunctional. It was just horrible what he was doing to her. And she made the decision to poison him. Mr. Narcissa, there's no motive. There is motive all over this case. Not only is there motive, there's means and there's opportunity. Judy Church was the only person with Leroy Fowler the night that he died. Leroy was a perfect victim of ethylene glycol poisoning. His diet seems to have consisted entirely of soda, Powerade, cupcakes, and coffee milkshakes. Those were his 4 food groups. The man didn't eat anything or drink anything that wasn't pure sugar. The perfect vehicle for hiding ethylene glycol in the poison you're going to give somebody. Now, if Judy and Leroy's toxic and dysfunctional relationship provided the motive, that night is the means and the opportunity. You heard from Dr. Shin and you heard from the medical examiner how quickly the ethylene glycol starts to poison you once it gets into your body. The only person that was there that night with Leroy was Judy Church. Now, Leroy knew enough to not drink ethylene glycol on his own, right? Leroy worked on cars, he worked on motorcycles all his life. Leroy knew how dangerous this stuff was. And Leroy liked cocaine, right? That's what Leroy was looking to do. Leroy was looking for cocaine. And Leroy was doing whatever it is that Leroy wanted to do. Now, what's the first sign on November 11th that something is amiss? Now, I'm not talking about Leroy's illness, but what I'm talking about is the 911 call. What does Judy say in the 911 call?
Yes, 108 Central Ave. We need an ambulance. Hear what's going on there? I don't know. My boyfriend must have ingested something.
My boyfriend must have ingested something. How did she know that he had ingested something? People only use the word ingest when they're talking about poison. No one says, I just ingested some water, or I just ingested my morning cup of coffee. You ingest poison. And Judy used that word because, not because she was admitting that she committed the crime, but because that's what was on her mind. She knew full well that he had ingested something. Now, the EMTs show up, and they don't know that he's ingested something. The first thing that they say to each other is, oh, maybe it's neurological, right? They take him to Anna Jakes. Anna Jakes doesn't know that he ingested something right away. They're still working. They're trying to figure out what happened to him. Doctors, nurses, nurse practitioners, they don't say, oh, yeah, he must have ingested something. No, only Judy Church says he must have ingested something, knowing full well that that's actually what happened. Before the EMTs get there, there's the videos. Those videos are horrible. They are chilling. They are the best possible evidence of murder in the first degree with extreme atrocity and cruelty. Usually you have to rely on a medical examiner or a doctor or a witness to say, oh, the victim was suffering. You don't have to rely on any witness. You don't have to rely on any person who came in and testified. You get to see for yourself how much pain, how much agony, how bad it was for Mr. Fowler that morning. He can't stand. He can't get up no matter how many times he tries. He can't talk. He can't breathe. He is moaning and moaning in agony. What does Judy Church say to him? Are you having fun?
Having fun?
If the person that someone loves is on the floor, unable to stand, unable to walk, unable to talk, you don't pull out your phone and you start videotaping. You call 911. For any of those things, you can't stand, you call 911. They can't talk, you call 911. They can't breathe, you call 911. Their stomach is like that, you call 911. He's got all of these things. And for a half an hour, she sits on that bed and she videotapes him. She tells the police she gave him a pillow, she gave him a blanket. It's not on the floor, nothing. The only thing that's on the floor is the dog bed. She never mentions to the police that she took these videos. She never mentions to Anna Jake's hospital that she took these videos. If you wanted someone to get better, if you wanted to help somebody, wouldn't that be the first thing that someone would show the police or someone would show the hospital? Hey, take a look. This is what he looked like. This is what he looked like for a half an hour. Maybe this will help you diagnose him. Maybe this will help you figure out what's wrong with him. In one of the more surreal moments of the trial yesterday, you heard Mr. Narkunis cross-examining the medical examiner. And he had the medical examiner agree that, yeah, if Mr. Fowler had gotten treatment sooner, maybe he could have lived. Who's the person responsible? Who is the person responsible for Mr. Fowler not getting immediate medical treatment? The defendant, Judy Church. She sat there in that house videotaping him for 30 minutes. She tells the police as early as 6:30 that morning he started to fall down. She told the hospital as early as 3:30 that morning he was falling down and that he couldn't stand up. Now, at some point, it had to become clear to her that explaining a dead body on the floor of her bedroom was not a good idea. She calls 911. She gets the chance to have her own narrative with the EMTs, with the police officers, with the firefighters that came. Oh yeah, perks. This is perks. I saw this before in 2019. There's no perks in his system. He never took any perks. She tells the police, oh, it's perks. There's no perks. There's none. They never find him. She tells them he had them. There's no evidence of that. Only her word. Even before November 11th, it appears Leroy was ingesting ethylene glycol. His symptoms, as described by Michael Hawkins, were the same symptoms that you heard about for stage 1 of ethylene glycol poisoning. You heard Dr. Shin from Mount Auburn talk about the kidney problems, the kidney failure that it looked like Leroy was experiencing, and how that could have been, how concerned she actually was for someone who's not even with us anymore about the fact that he couldn't urinate. One of the most serious symptoms that she could tell you about kidney failure. Judy talked openly to everybody about poisoning Leroy Fowler. Now she says it's a joke. As Tammy Fowler said when she was on the stand, it's not so funny after Leroy is poisoned. She texted people about poisoning. She texted, I want to poison somebody, and I have somebody picked out. This was in September of 2022, weeks before Leroy died of ethylene glycol poisoning. Told the police how they used to watch true crime. She called them the murder shows. Perhaps in answer to Mr. Narkunis' questions, that's where she learned what ethylene glycol could do. During that first interview with the police, when did she show the most emotion? Not when talking about Leroy's condition, but when they mistake her for the other girlfriend, for the visiting girlfriend. She says, I'm not the visiting girlfriend. Two months before his death, she took a picture of his room. And it was that exhibit that we talked about a couple days ago, the orange liquid in the cup. See it on the screen. The defense insisted, no, it's red, it's red, it's red. Well, Sergeant Williams insisted, no, it's orange. And you can see it's orange. And it's exactly the same color as the liquid in the Powerade bottle. Why would anyone take that picture? Why would you ever take a picture of that on your phone of what somebody's drinking? Is it another trophy? Like the videos that she took of Leroy as he lay dying on her floor? We don't know, but what we do know is that that orange is the exact same color as the orange in the Powerade bottle. That picture taken in August of 2022. What else? The murder weapon, the Powerade bottle. It was found in her kitchen. It has her DNA on the mouth of the bottle, underneath the cap. That's not transfer. That did not sit in that recycling bin and pick up DNA underneath that cap. You heard Ms. Hooper tell you, she swabbed the mouth and she swabbed the underside of that cap. It was not picking up DNA from anywhere. No matter, Mr. Lakin can tell you about transfer all he wants, but DNA really does come from touching things and drinking from things. Her DNA is on the mouth of that bottle. She drank from that bottle. She drank. Did she finish the Powerade? Did she show it to Leroy so that he would think it was safe? Take a little sip? She tells the police actually that night when Leroy came to her bedroom, she thought he was dehydrated. She showed, yeah, I gave him something to drink. Now the defense rests much of their defense on the bittering agent that they say would have kept Leroy from drinking this because he would have noticed it. Now, you heard from NMS that they don't have this test. State Police Crime Lab doesn't have this test. Now, and the defense says, well, the state police, Trooper Williams, should have gotten this test done. Can you imagine the uproar from the defendant if the Commonwealth of Massachusetts had called up a random marijuana testing company with no forensic abilities at all to do a test in this case? Can you imagine the outcry? Mass State Police call weed company testers to test evidence in a murder case. Now, these are the same people, when you heard the testimony yesterday, that provided their results to a different defense expert 2 months before they actually did the tests. I think the less said about MCR labs, the better. Those bittering agents exist to keep people from drinking straight antifreeze. They don't exist to keep people from drinking antifreeze that has been mixed in with soda or Powerade, that it's down to 2.5% of the bottle. That's not what it's there for. You're not going to take that. You're down to 1 or 2 parts per million at that point. Regardless of the Bitrex that was in that Powerade, one of the uncontrovertible facts of this case is that Leroy Fowler had ethylene glycol in his blood. He had it in his body. He had it in his system. That's what he died from. Dr. Shin agrees. The medical examiner agrees. And if you look at the Beth Israel records, you'll see that that's what he died from as well, despite the representations made in the closing by Mr. Narkunis. Right at the top of the Mount Auburn records, it's right at the top of the differential diagnosis, is ethylene glycol poisoning. And that was before they even had the 52 milligrams per deciliter number of ethylene glycol in Mr. Fowler's blood. Leroy drank ethylene glycol within hours of that video being taken on November 11th. He had to have drunk it in the house. He had to have drank it that night. Judy Church had complete and utter access to his food and his drinks. In her interview, you heard her say, you won't find Leroy's fingerprints on a pot or a pan. She did his cooking. She made him his drinks. She made him his milkshakes. He was the perfect victim. He had COVID and lost his sense of taste. He destroyed his taste buds with years of cocaine use and cigarettes. He was the perfect victim for an ethylene glycol poisoning murder. That is motive, means, and opportunity. Leroy didn't kill himself. If he had, the bottle of antifreeze would have been sitting in his bedroom, right? Someone shoots themselves, the gun falls to the ground. It's there underneath the body. Someone takes pills, you take a whole bottle of pills, the pill bottle is there. There's no antifreeze there. If he had been drinking that himself, just drink it, kill himself. No, there's absolutely no evidence of that. As Judy Church told the police numerous times, oh, Leroy thought far too highly of himself to kill himself. Not a single person came in here and gave a shred of evidence that suggested that Leroy Fowler was going to kill himself. Leroy Fowler liked his life. He liked having Judy buy him things. He liked being able to go to Barbara when he wanted to. He wasn't the one with the problem in this relationship. Judy was. Now, a few minutes, well, that's actually been a long time now. Almost an hour and a half ago, the judge explained to you the elements of first-degree murder, the two theories that the Commonwealth is proceeding under, premeditation and extreme atrocity and cruelty. Now, with respect to premeditation, there are few things in the world when you're going to kill somebody that require more premeditation than taking a poison and adding it to someone's drink. The very definition of having to think about what you're doing, unscrewing the cap, pouring it in, making sure that they drink it. And as for the extreme atrocity and cruelty, that video provides all the evidence that anyone would ever need to know that this murder was committed with extreme atrocity and cruelty. Leroy Fowler was not always a good man, but he did not deserve to die the slow, horrible, painful death that Judy Church inflicted on him. All that she had to do was leave. All that she had to do really was kick him out. He didn't have a house. He didn't have any money. It all came from her. But she couldn't do that, right? Because she couldn't let go of this competition that she had with Barbara. One of the notes that I read to you yesterday said, you'll lose this competition every single time. You will never, and I'm paraphrasing, you'll never defeat me. You'll never beat me. That's what caused this. That's what brought along what happened on November 11th. That's what caused the poisoning of Leroy Fowler. I ask you that after your deliberations, you return a verdict of guilty on both theories of first-degree murder and find her guilty. Thank you.
Thank you, Mr. Camellia. Now, jurors, we're going to get back to the instructions. The first part was about 20 pages long. The second part's about 20 pages long as well. We'll probably push a little bit past the 1 o'clock hour, but I would like to get these. If everyone's good to, everybody still good to go? All right, we will finish these instructions and then. Okay. We will take a very quick break and then we will finish the instructions. That's fine.
All right.
All right, so we get a little bit of a break here to go over this. Maybe this is a good time that I can share a couple things. Thanks to Griffin Little Leroy, who's with us here in chat. We've been given permission to share something, and I was telling you that at a funeral, we highlight the best of somebody's life, right? We try to overlook the flaws. We look at the good things. We look at the good memories. In a court case, in this case, the victim has been just painted as a terrible person. And really, the defense has had a lot of leeway to do that to their heart's content, to describe him as just the worst person you could possibly believe. Leroy has shared a couple images which I'm going to share with you that can, well, if I can get this to work correctly. Helps if I plug it in. Shared a couple images that we're going to share with you guys that will help you see the other side of Leroy that wasn't shown in court. And Thal, thank you. Culliver, good to have you here. Welcome. We know you're always lurking somewhere. Let's see. Just a few pictures for you to show the kind of person that Leroy was. And these are shown with permission here. Especially the relationship he had with, this would be, I believe, his grandchildren, which hits me right in the feels because I'm about to become a grandparent today as well. Griffin was sharing with me that his son slept with Leroy's ashes and with his Harley Davidson jacket for quite a while after Leroy passed. Which just, but Griffin, thank you for sharing those with us. I know that. Sorry, I disappeared off here. I know that. I know these stories don't get told properly, and you know, when you get up on the stand and are fired questions at you in rapid succession, and you get to answer only the way that the question the lawyer puts it as he puts it to you. A yes or no doesn't fill up and doesn't convey the happenings, right? It doesn't tell the full story, and there is a full story here. And you know, we heard that a little bit in the closing for the prosecution. This man did not deserve what he received, and that's evidence. So. My heart goes out to you, also your family, everybody as they continue the grieving process here, and hopefully this will bring you closure and a measure of peace to you all. But thank you for giving us a little peek behind the curtain as far as who Leroy was. But I appreciate that. Yeah, and a shout out to Kiss. You saw the Kiss shirt, right? I saw that as well. That's awesome. All right. With that, we're sitting sort of in a holding pattern just for a couple minutes while we wait for the rest of the instructions to be read. And I apologize, there's a little bit of sound in the background. YouTube is talking to me in my other ear. There's a live meeting going on I'm trying to ignore. But, all right. We're all good. There we go. The prosecution and the defense only used defense used about 45 minutes, I think, on their closing. The prosecution used only about half an hour, by my count. My clock was a little bit off, as is my count for the cough counter, which is up to 1,054. Pretty much every other trial except for objections in the Maya trial. We've never had a 4-digit counter. We stopped at 1,000 in other trials when they just got too much to count. But with only hitting 1,000 on the last day of the trial, it's something that I'm okay with keeping here as we continue. This is the plague courtroom. It really is. All right. The Jim McIntyre, yes, Jim McIntyre references. The judge started coughing. Oh my goodness! I'm glad we started coughing. Counting the coughs early on. It was so bad. It's the only way I could have gotten through. You know, having a little lighthearted counter with the coughs going on, because it's just right into the mic. It's full on. It's like he grabs the mic and gets nice and close, and then takes a big breath and just lets it rip. So crazy. Let's see. Sorry. Try not to let you hear that audio while I can still hear it. So, let's see. Never forgiven you for making us sit through these mouth noises. It is what it is. Let's see. Can you imagine if we called the trial off for the flu? Oh, it would have been terrible. It would have been terrible either way. talk about it would be still extremely expensive and hard for the family as well as for the facility. But just everyone's sick right now, so. All right. Did defense close first? No. Oh, yes. Defense went first, and then the state or the prosecution. Let's see. I've got Thal on the phone. Let's see if we can bring him on. Just one second.
Call from.
Thal, how's it going, my friend?
Pretty good. You know they're going to come back now that I called you.
That's the plan. That's the plan.
Yeah, so here's my idea, okay?
Yeah.
So I asked who's coughing in court, and the chat so lovingly explained to me everyone. So what we have to do is you have to purge the court, okay?
Mm-hmm.
Start all over because we can't have zombies. You know why?
Tell me why.
Because zombies don't like pickles, and you think I'm going to stand for that heresy? No, I won't.
Right. Okay. Well, thank you. We haven't heard you for a while. How's life? Is everything going well for you?
Everything's going pretty good. Yeah. She's doing good. Grandbaby's doing good.
Wonderful.
It's kind of boring. I'm thinking of leaving the country for a while.
Yeah.
Gonna go jaunt around.
So
I figured out.
What's the reason?
Well, no, it's okay. So the reason I'm feeding the reason I'm feeding everyone else is officially because I want to explore the world and find my roots and have dainty things and travel the world and see these exploitative, beautiful places. Actually, it's because our money is worth 10 to 1 in just about every other country I can find. So
now is the time to spend it then.
Yeah. Well, hey, here's the thing. I'm 100% disabled, permanent and total.
We're back on the record with
I get paid no matter what.
Okay, they're back. Thal, thanks for calling because that made it happen. I appreciate it. It's good to hear you.
See, I told you.
We need to talk again soon.
This is what I usher in.
All right. Thank you very much.
See you, buddy.
Bye.
All right, pretty good.
All right. Now the judge is going to finish maybe another 20 minutes, and then it'll basically take us to lunch break, and we'll start deliberations then.
Jurors, for those who are reading along, I am now on page 20 of the instructions, part 2 after closing arguments. Jurors, you have the most important role in this trial because you alone must decide who and what to believe and whether the Commonwealth has proved Miss Church's guilt beyond a reasonable doubt as to the charge before you. You must be completely fair and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. As I told you earlier, you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of the witnesses, as you recall it, and the things that were marked as exhibits and any stipulations of the parties. Again, a stipulation is an agreement between the parties that the recited facts are true and should be accepted as true by you without the need for any supporting evidence having been presented. You will have all the exhibits with you in the jury room. There are other things that are not evidence, and you may not consider them when deciding this case. They include the following. The fact that Ms. Church has been indicted or charged in this case is not evidence. Questions that a lawyer asked of a witness are not evidence. Only the answers are evidence. For example, if a lawyer asked, "Wasn't it raining outside?" and the witness answered no, or said, "Well, it was cloudy," the question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection, and therefore the witness did not answer it, then neither the question nor the fact that the witness did not answer is evidence. If I struck or told you to disregard any part of, or all of an answer by a witness, then that part of the testimony is not evidence and you may not consider it. Anything that you may have seen or heard when the court was not in session is not evidence. Any notes that you have taken are not evidence, but you may use your notes to refresh your memory of the evidence. As for the opening statements and the closing arguments, while you may consider them in assessing the evidence you have heard and in deciding what facts to find and conclusions to reach, I remind you that they are not themselves evidence. Your role in this case is the most important one because you and you alone will determine what the facts are. In a sense, you are judges when you do that. You are the sole judges of the facts. It does not matter what I or the lawyers think the facts are. All that matters is what you find the facts to be. Consequently, you should draw no inferences, favorable or unfavorable, to either side because of anything that I, as the judge, may have said or done during the trial of this case. If you think that during the course of the trial I made certain rulings that suggested how I felt the case was going, or how any issue of fact should be resolved, or how you should find the facts, then you are to ignore such belief because I did not intend to do so. I have no view of the facts of this case. Again, it is you and you alone who must decide the facts of this case, and you must do so free from interference from anyone, me included. You alone will determine the weight and the effect and the value of the evidence and the credibility, that is the believability of the witnesses. Once you make those determinations of fact, it is then your duty to apply those facts to the law as I now give it to you. In deciding what the facts are, you all have certain tools available to you. The primary ones are your own common sense, good judgment, and general life experiences. Evidence can come in different forms. The primary ones are testimony by witnesses about what they saw, heard, did, or experienced, and tangible items such as documents or photographs that were marked as exhibits. Some evidence proves a fact directly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that is direct evidence that it was raining. Some evidence proves a fact indirectly. That is also what is known as circumstantial evidence. For example, let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off an umbrella. That is indirect evidence that, if you believe it, might lead you to conclude that it was raining outside even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove that something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some information that we know, we apply our intelligence and common sense, and then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. The Commonwealth may be able to prove a criminal charge with direct evidence, indirect evidence, or a combination of both. A very important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it, or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or was deliberately lying. If you conclude that a witness lied to you about something, then of course you should not believe that part of the testimony. You may also decide, or not, that such a lie causes you to disbelieve other testimony by the witness. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something but actually be mistaken. For example, a witness might not have paid close attention or might have misunderstood what was happening, or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful, but that some part of the person's testimony was not accurate, then you should not consider the inaccurate testimony. You may also decide, or not, that such mistaken or inaccurate testimony causes you to disbelieve other testimony by the witness. How do you decide whether you believe particular statements by a witness? Ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Does the witness's memory seem accurate? Was the witness's testimony consistent with other evidence or instead contradicted by other evidence? How did the witness behave and answer questions? Did the witness have any motive for testifying in a certain way or have any other bias that may have influenced the witness's testimony? In assessing the credibility of a witness, you may consider whether, prior to the trial, the witness made any statement that was inconsistent in some way with the testimony the witness gave on the witness stand. That is, the prior statement differed from or contradicted the witness's testimony here in court. That is what is known as a prior inconsistent statement. Unless the prior statement either was adopted as true by the witness on the witness stand, or it was made under oath, such as before a grand jury, the prior statement is admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that a witness made such a prior inconsistent statement, it is for you to decide to what extent, if at all, the credibility of the witness is adversely affected by it. But you may not consider the earlier statement as evidence or proof of the truth of any fact contained in the earlier statement. Again, unless the witness either adopted the prior statement as true or the prior statement was made under oath. During trial, you also heard you also heard one or more witnesses testify to making some statement at an earlier time that you might find was consistent with or similar to some aspect of the person's trial testimony. That is what is known as a prior consistent statement. Normally, under our rules of evidence, you may not consider any statement that a witness made in the past which is similar to that witness's testimony at trial. That rule rests in part on our common experience that saying something repeatedly does not necessarily make it any more or less true. But we make an exception to that rule where there has been a suggestion that a witness may have recently contrived their testimony. In determining how reliable a witness is who has been accused of recently inventing their testimony, you may consider any earlier statements that the witness made which are consistent with the person's present testimony. It is for you to say how important the consistency is, depending on when any earlier statement was made and any other circumstances that you consider significant. The earlier statement is not itself positive evidence of any fact that is mentioned in it. To repeat, if there has been a suggestion that a witness recently contrived their testimony at this trial, or some portion of it, then you evaluating that claim, you may also take into account any earlier statement the witness made which is consistent with their trial testimony. The prior statement is relevant only as to the witness's credibility, and you may not take it as proof of any fact contained in it. You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way you would evaluate anyone's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer or works in some law enforcement capacity. I want to repeat an instruction I gave twice during the course of the trial with respect to statements that were attributed to the deceased, Mr. Fowler. One was a statement that Tammy Carbone testified she heard the defendant, Ms. Church, make, in which the defendant purportedly related a statement that Mr. Fowler had made to her. A different witness, Michael Hawkins, testified about the other statement, which he related that Mr. Fowler made to him directly. I want to emphasize to you once again, as I did in my earlier instructions, that it is entirely up to you to decide whether and to what extent you credit any testimony regarding purported statements by Mr. Fowler. And it is for you alone to determine, based on such assessment, whether Mr. Fowler made either statement. But if you do find that Mr. Fowler made either or both of the statements in question, you must bear in mind that those statements were admitted for a limited purpose, and you must confine your consideration of the statements to that specific purpose. The statements were admitted as evidence of Mr. Fowler's state of mind prior to his death. You may consider Mr. Fowler's state of mind in assessing whether or not he ingested ethylene glycol knowingly and intentionally. But you may not consider either statement for the truth of Mr. Fowler's stated belief regarding the defendant, Ms. Church, or her conduct or intentions. That would be an impermissible and forbidden use of that evidence, and it would be unfair to Ms. Church. Most of the testimony during the trial came from witnesses who saw or heard something. Several witnesses, however, such as the medical examiner, told you about opinions or conclusions they reached based on some special training or experience. We often refer to such testimony as expert testimony. But even if a witness has some special training or experience, that does not necessarily make the witness's testimony any more believable or important than other testimony or exhibits. You must decide whether you believe an expert witness and how much importance to give to the witness's testimony. You should consider all the factors I have previously mentioned, including whether the witness had a motive to testify in a certain way or some other bias that could have influenced the witness's testimony. In addition, as you evaluate an expert witness's opinions or conclusions, you should also ask, was the witness's testimony supported by the facts of this case, as you find those facts to be? Did the witness use guesswork or assumptions that you do not find to be convincing or are not consistent with the facts, as you have found the facts? Did the witness have sufficient education or experience? You may decide to accept all, some, or none of the opinions or conclusions offered by a witness. But please remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you to decide this case and to decide whether you accept or reject any opinion or conclusion that a witness offered during the trial. You may have taken notes during the trial. Your notes may help you remember the evidence, especially the testimony, but of course they are not an actual transcript or official record of what was said. So use your notes only to help you remember what you heard and saw during the trial. Whether you took notes or not, you must rely on your own memory of what the witnesses told you. After the trial is over and you have returned your verdict, a court officer will collect your notes and destroy them. It is also up to you to decide how important each part of the evidence is, whether it is testimony by a witness, an exhibit, or a stipulation. Whether evidence is direct or indirect, you should give every piece of evidence whatever significance you think it deserves. You are not required to believe something simply because it appears in an exhibit. It is up to you to decide how important any exhibit is. You do not have to treat testimony by the witnesses as more or less significant than the exhibits. You may find that a witness's testimony is very important or that an exhibit is more important. That is up to you. I want to address another important issue that I discussed with you in my earlier instructions, fairness considerations. I will be repeating and expanding upon what I said then because this issue is so important. Each of you has taken an oath and promised to be fair. I am sure that you want to be fair, but that is not always easy. Part of being fair is being willing to examine your decision-making process to be sure you base your decision as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them. We all have them simply because we are human. They affect our actions and decisions without us even realizing it. You may have heard this called implicit or unconscious bias, and that is what I am talking about. We judges have the same problem as everyone else, so let me share a few strategies that we have found useful. These strategies will help you make sure you decide this case based only on a careful examination of the evidence and on the legal rules I have explained to you. First, slow down. Do not rush to a decision. Take time to consider all the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we may not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were in different social or economic groups, or had different occupations, or had different ages, genders, gender identities, or sexual orientations, or came from different racial or ethnic backgrounds? Fourth, listen to one another. Other jurors may have different points of view. If so, they may help you make sure you are focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions, so don't hesitate to share your views. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you think is important. When you explain your thoughts to other jurors, you help everyone focus on the evidence. If you do these things, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. I'm now going to give you some instructions about how to conduct your deliberations. First of all, you must keep your deliberations secret. You should not tell anyone outside the jury room, not even me, anything about them. For example, please do not tell me or anyone else the results of any votes you may have taken before you all agree on your verdict. You must not tell anyone how your discussions are going or what any jurors said. If you need to communicate with me before you reach your verdict, you should send me a written note in a form you all agree on. It must be signed by your foreperson. I will discuss your note with the lawyers. Then I will either send you a response in writing or bring you into the courtroom and respond to you in person. If you do send me a note, it should not mention any votes you may have taken or anything else about your deliberations. Do not talk about the case unless all of you are present and no one else is in the room. If one of you needs to leave for a moment, the rest of you should stop deliberating until that juror returns. If we break for the day before you reach your verdict, you must not communicate with other jurors about the case until the next court day and only after we gather in the courtroom and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with an electronic device such as a cell phone or tablet. This also applies to the alternate jurors. You will be provided with a verdict form on which you will record your verdict, whatever it may be. There are several options on the verdict form in accordance with my instructions. The options are not guilty, guilty of first-degree murder on a theory of deliberate premeditation, guilty of first-degree murder on a theory of extreme atrocity or cruelty, and guilty of second-degree murder. Your foreperson will sign the completed verdict form and present it in open court when asked to do so. The law permits only 12 jurors to participate in deciding a criminal case. We started with 16 jurors. We chose 16 of you originally in case one or more of you got sick or had some other unexpected emergency.
I think they all got sick.
In a few minutes, our clerk will randomly select 4 of you to serve as our alternate jurors. The other 12 of you will work together to decide this case. If you are chosen as an alternate juror, your continuing service is still very important, and you must comply with all the rules I've given you. The alternate jurors will stay in another room from the deliberating jurors, and they must not discuss the case with anyone else or with each other. If we were to lose a deliberating juror because of some personal emergency or sickness, a replacement juror would be randomly selected from the 4 alternates and sent into the jury room. If there was need to exercise a second deliberating juror, we would randomly select one of the remaining 3 alternates and send that juror into the jury room. By the way, anytime that we do have a need to replace a deliberating juror with an alternate, the newly constituted jury is required to restart all its discussions from the beginning. One of you will serve as foreperson of the jury. The first order of business of the 12 deliberating jurors will be to select one among you to serve in that role. The foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinions of all other jurors. As I've already stated, once you agree on your verdict, the foreperson will fill out the form and will report your verdict in court. When you work together as a jury, you will be making a decision as a group. This kind of decision-making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach your verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You have all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. So you are all equally qualified to reach your verdict. I have a few suggestions that might help you as you work together. First, you should discuss and analyze the evidence before you take any vote about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, as I said before, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as the other jurors talk about the evidence that they found important, please listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your thinking. Fourth, don't be shy. As in any other group, some of you will be more comfortable than others in sharing your thoughts. But you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one who remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it is the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, you each must decide this case for yourself. I'm going to see counsel for just a moment at sidebar, and then I will be right back with you to conclude my remarks and select.
All right, as the fire trucks are zipping by outside, judge is just about done. I think he's going to ask counsel if there's anything he messed up or he needs to fix with the jury. Are they good with everything? As soon as this is done, we're going to pick our alternates. The alternates are going to get locked in a room by themselves where they can't talk to anybody about the case and just have to sit there and wait. And then deliberation will begin right about lunchtime. So we're going to go to lunch and then let them deliberate. There's another cough. We're going to be like 100 over. 1080 right now.
It is now time for our clerk, Ms. Draper, to randomly select 4 of you to serve as our alternate jurors.
It's my favorite clerk ever. Spin the wheel, spin the wheel. 1. Look how fair this is. 2. The ASMR even helps. 3. 4. See, there's no...
In seat 4, juror in seat 6, juror in seat 13, and juror in seat 15. Then that's 4, 6, 13, 15. You've been selected as alternates. You may remain seated for right now.
Would those jurors just raise their hand for a moment? You can remain in place, but I just want... we've got 3? Do we have 4 hands up? There we go. Okay.
Mr. Leno.
Whoa.
Okay. You're also.
To those alternates, let me just say before I proceed, I know it feels like you just got voted off the island, but you saw that it's a completely random process. But I also just want to emphasize what I told you in my formal instructions, which is your continuing service remains very important to us. Sometimes alternates get pressed into service during deliberations.
Corey, welcome.
And so we are very grateful for your continuing participation, and I want to thank you for that right now. In a few minutes, the deliberating jurors will go and start their private discussions. To those 12 jurors, I now say, have confidence in what you are about to do. By serving on this jury, you carry on a long and proud tradition of citizens serving in jury trials in Massachusetts. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict. Jurors, the attorneys and Ms. Draper are going to work to get all of the exhibits in order. They'll be coming down to the jury room imminently. You've got your lunch waiting for you, I presume. We do. And the alternates will have their lunch separate from the deliberating jurors. A laptop will be provided to you. This is a pristine laptop for playing of any electronic media, so you decide what to play, but you can view all the exhibits, including the electronic ones, as much as you wish, and you can use that device for the electronic media. So with that, we will have our court officer sworn.
Yes, Your Honor. Do each of you solemnly swear that you will keep this jury in some convenient place until they are agreed, that you will not suffer any person to speak to them, nor speak to them yourself, unless by order of the court, or to ask them if they have agreed? And when they have agreed, you shall return them into court, unless the court shall otherwise order, so help you God.
I do.
Thank
and
you.
With that, I'm going to excuse our 12 deliberating jurors to have lunch and commence their deliberations, and our
All right.
Minutes to commence their patient waiting.
Judge, you can bring your books with you now.
Everything may go with you.
Oh, sorry.
The four alternates are coming here.
No, everybody's going to go with the court officer. They'll direct you where to go.
All right. When the door shuts, we start the timer.
Are you taking a lunch break before we get the exhibits together? Ms. Draper?
Excuse me?
The exhibits, are you doing that now or after the lunch break?
Sam's going to go with you.
I'd leave it to you.
I'll discuss it with,
Okay.
with
Judge-
counsel, Your Honor. I mean, they
All right.
will be having their lunch
Yep.
right now.
Just one thing. Yesterday, I referred during the testimony of, I forget his name actually, the gentleman from MCR Labs, to that the wearing report that I used
Yes.
in the cross-examination. I thought we should perhaps mark that
For identification?
identification.
That's fine.
No objection.
Happy to do that.
Your Honor, for the record, I did mark the court's instructions to the jury a copy as Q, so this will be R.
This will be R.
This is
Okay.
correct.
R for identification
Yes.
is Ms. Waring's report. All right.
Just so the record's clear, Attorney Scully and I discussed the medical records, and there's no redactions that either party is requiring.
Very good. Excellent. All right. Well, I'm about to recess, but I want to thank all counsel for their efforts in this case. It's clear to me that both the Commonwealth and Miss Church were very ably represented in this trial, and beyond that, it's really a pleasure for me dealing with each and every one of you. I have no idea how this case will come out, but at this juncture, I wanted to express my gratitude to all of you for your efforts in this case. We'll be in recess.
Court, all rise.
All right, with that, we're going to end our cough counter.
We can do this now. It's fine. Yeah, sure.
Let's do it now. Screw it. We'll do it live. All right. Cough counter officially ends at 1,088. We are now going to bring over our timer, our stopwatch. Which, give me a second. Let me get this squared away. Make this one smaller. Hold, please. We're going to get there. There's just one of me doing this, so. Okay, I'll bring that in right there, and then make it bigger again. Make it much bigger. Oops, keep going. Okay, how's our clock looking? It's on there at least. We've got some seconds. I'll see if I can improve it a little bit as we go. We're gonna go to lunch after we do one more poll, and that poll is how long will the jury deliberate? Give me just one second here, and then I also have some pictures to show you, some additional pictures, courtesy of Griffin or Little Leroy. Just one second. I think I spelled everything correctly. Our options for deliberation are going to be I'm going to do 1 to 2 hours. 1 to 3. Let's do 1 to 3. 1 to 3. 3 to 6. 6 to. I'm going to do 6 to 8. Sorry. Math is hard for me. Or longer. There we go. Sorry if I messed up that poll. It was a little bit rushed, but timer's going. Are they deliberating during lunch? That wasn't very clear. Apparently the jurors are getting fed separately. So it's possible, with the lunch being brought in, that they are deliberating through lunch, and we may hear this. Griffin, I'm not sure if you're sure. We have what's called verdict music we play at the when the verdict comes in. We do that for a couple of reasons. First of all, a lot of the viewers watch this while they're busy doing other things around the house, at work, in the garage, and sort of just keep it in the background. The verdict music is just to let them know that a verdict is in. It's never a celebration. We play it before the verdict is announced and not after. So we expect that if a verdict comes in, you can hear that music. But also, you provided just a few more photographs. I'm having trouble sending all of them, but I'll show a portion of them here. That just really gave us a peek into who Leroy was, because what the story that was told in court was not who Leroy was. That's the story that the defense wanted you to think Leroy was, and we have a few pictures. Give me just 1 second to get some of them up here. Let's see if I can get some of these shown here. Just one moment here. Takes a minute to move them over. Show some of these here. These are some awesome pictures, by the way. Just some awesome pictures. Clearly, amazing family guy. The story that didn't get told in court. So thank you for sharing the pictures with us and giving us permission to share it to sort of paint the picture of who he was. And I'm going to end on this one. That one gets me right in the feels. Griffin, thank you very much. I appreciate it. Thank you also for being here. I realize it can't be easy to walk into a true crime channel where your family is up on the big screen, and a lot of us are watching court because we enjoy court and we like the legal system. For us, it's quite distant, but for you, it's quite raw and real. And I appreciate your patience with us as we do what we do and try to do it in a respectful way. And I appreciate you being with us and help us understand some of the stuff that wasn't made clear during the court itself. And wish you and your family all the best. So thank you very much. With that said, we're going to go to lunch. We're going to go to lunch. The timer is going to continue counting. I'll bring up the timer in just a minute. We'll be back in just a little bit, just a brief. I think we'll be back before 2, so less than 40 minutes. If you hear of a verdict coming in, please shoot me a quick buzz on the burner phone. We don't want to miss anything. I don't think we will, but I want to make sure everything's done and ready to go. So, oh, you have Salt. Oh, that's awesome. That's awesome. Salt being the pup. All right, Wendy, I did not find the missing package. I have not found that one. We're looking. We're going to go to the post office and see if they missed it somewhere. All right, with that, we're gonna go to a quick lunch. Thank you all for being here. I appreciate it. Thank you for being a community where family members of victims feel comfortable to come and watch court. I appreciate that. It's an honor. It doesn't happen with every trial, but it's happened enough that we know that there's something special about this community, and that's because of you guys. So thank you very much for that. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe. We'll go live again after lunch. After lunch, we'll be, you've got like 40 minutes max to get your lunch in. And we'll be back here with, yes, we'll portal. Oh, I should do a portal, huh? That way you know we're coming back. Give me a second. We'll have a portal made for you. It's the quickest I've ever made a portal, but I'll update the photo on it as well, Red Pen, if I don't remember. Remind me. Link. There we go. All right, portal's in place. All right, guys, have a good lunch. We will see you afterwards. You're all amazing. Happy Friday to you. We'll be back this afternoon. Appreciate y'all. We'll see you.
Is that correct?
Oh, and no grandbaby yet. Just no grandbaby yet. Hold on.